bond. They use this what's so called a bond agency, bond agency pricing. It is an institution's providers for Sukuk pricing. So normally they will leverage on such institutions to determine such a pricing. And if you use this formula, which is below in the following example, if we have, let's say, a bond with annual coupon payments, and let's say assume that the company, it's the Central Bank of Bangladesh that has issued a bonds where the face value of the bond is 1,000 and have a coupon rate, which is the annual rate on a 7%. Of course, when it's come to the annual payments, sometimes it is annually, sometimes it's semi-annually, sometimes it's a quarter. So if it is semi-annual, you have to times 2. If it is a quarterly, you have to times 4. But if it is annual, you take it as it is. And you have the tenures. Then you have the prevailing market interest rate. Then you will use this formula where the F is the face value, C is the coupon, which is 7% times 1,000, the face value, then you get the 7,000, then the 7,000, then you have the 15 tenures, then you have the 9, which is the what's so called interest rate in the market. Then use the formula, this one, and normally they use Excel, they use a formula of Excel. So what you have to do, you just key in the numbers. You just key in the numbers to get this formula, which is captured in the Excel format, meaning that you have to key in the face value, you have to key in the coupon rate 7, then you have to key in the 7, then the prevailing market rates, then you just click, then you will get the pricing, which is in this case 83,876.62. So this is some kind of very brief summary that indicates the way that what's called the Sukuk or the bond is a pricing. And normally, as I mentioned, either they will leverage on a third party like the bond agency pricing to help them to do the pricing, or they have their technical team where they use the Excel sheet, in order to key the relevant information in order to get the pricing. But this is what is known in a corporate finance formula. They use the discount cash flow when they use the present value with the kind of discounting and use this kind of formula in order to determine the price of the bond. Of course, this is a conventional formula, but again, we are talking about formal substance and we are talking about leveraging. In the conventional bonds, they basically fix interest, the rate of the interest is fixed, but in the Islamic, we have some Sukuk fixed as well, like for example, Ijara Sukuk, it is fixed. So you can see kind of similarity in the form, but of course the substance is different, but leveraging and benchmarking could be used versus the equity, where the equity, it is not fixed, but it is expected. So you can use it as well as an indication rate of return to do a kind of a pricing. But at the end of the day, it is a tool. It's like a mathematics. It's like a technical tools that can be deployed. Even it is a conventional, but it is deployed in the Islamic context to achieve a kind of pricing, because here we are talking about the pricing, we are not talking about the structuring. So that's the brief on the pricing Sukuk, but normally, as I mentioned, it is given to a technical team that using Excel sheet or to a third party, like in the case of bond agency pricing in Malaysia, which is provide international advisory on pricing as well for international players. Moving to the next point is the critical analysis of the IOF 2008 resolution and pronouncement. This is 2008 when, if you remember, Sheikh Taqi Uthmani, commented on the Sukuk in 2008, and IOF came up with a pronouncement of 2 pages that contain 6 clauses, and this pronouncement was on 13-14 February 2018. And this is it was as a result of 3 meetings. The first one meeting was in Medina 2007, then second in Mecca 2007, then the third in Bahrain 2008. So this pronouncement, I will just go briefly on it. If you have further information, you just, further inquiry, you can just post a question. But I will just go briefly. I will not read because you will have the slide later on. But just comment quickly on them, and they will be also coming with us later on when we talk about the tradability or the trading of the sukuk in the secondary market. Some of the points will be recap. Also, some of the points will be recap when we talk about the guarantee because they are interrelated. Now, as I mentioned, pronouncement come with 8 clauses. Sorry, 6 clauses. The first one talking about full ownership, meaning that sukuk holders should own the certificate and the underlying asset through via true sales, and they are having an appropriate and accurate ownership. Meaning, you cannot just claim that this is mine, but technically it is not. It is not yours. So you cannot claim ownership. It has to be full ownership. It has to be a true ownership. And here, basically, it's a long debate. I don't think we have the time to talk about it because I can spend maybe 1 hour on this issue. It's basically the issue, if you are aware about it, the debate between the legal title and the beneficial ownership. Of course, the debate is in the civil law, whereby they don't distinguish between the legal title and the beneficial ownership. But the common law, basically, there is a distinction. Of course, in the civil law, only in the case of lease, where they will distinguish between the ownership of the title of the asset and the usufruct ownership. But in the common law, basically, they have this kind of distinctions between the legal title and the beneficial ownership. In other words, from a common law standpoint, the title of the assets belong to someone, but the third party have the beneficial ownership. Now, in the eye of the court, the true owner is the one who has the beneficial ownership, not the legal title, which is against the civil law interpretations. Now, when it comes here to Islamic finance, so the debate could be, our discussions is based on civil law interpretation or common law interpretation. I think 3, 4, 5 years ago, it was an international conference on this, legal title and beneficial ownership, and all basically agree that Sharia has no problem to recognize the distinctions between legal title and the beneficial ownership, provided the custom, the commercial law, the court acknowledge that. And as you know, the Urf is a very strong reference for that, and it is acknowledged by Sharia. If you don't have a problem with that, especially in the context of the common law, so you have no issue. That's point number one. Quickly on point number two, which is related to the full ownership, sometimes transferring the asset from the book of the originator, it's practically difficult, especially in the sovereign sukuk. Sovereign sukuk. Meaning that imagine, for example, a government want to issue a sukuk, right? And they put some government building. Then, based on the rules, those assets should be off balance sheet from the government balance sheet on a SPV with in a favor of the investor. Investor could be from a foreign investor. So, meaning that, in other words, the foreigners will have a full ownership over government property. That's number one. Number two, who has the authority to move the balance sheet, the assets from the balance sheet of the governments to a third party? That has an issue, and it created a very strong debate in Egypt when they want to pass the law, when they talk about the true sales and the ownership process and the SPV and the relationship between the originator, the issuer, and the what's so-called investor. It will become a really political debate in the TV. It became a big debate and big noise because of this. So because of this issue, the common law interpretations become a way out to provide the solutions to the problem, which means that it doesn't mean your name is on the title of the asset is disqualify you from being owner of the asset. So that's basically the solutions. And also from the other point, we are looking at the interest of the investor, because basically you cannot say I own the asset, but practically you don't have a full ownership over it. So that's basically the debate. So the summary of this point from the IOFI standpoint is that you have to have a full ownership, which is not debated. Only the thing is that what are the evidence to support this ownership? Is it? It has to be on your balance sheet. Is it should be off balance sheet of the issuer. Is having the legal title and the beneficial ownership on the same asset creates a problem from a Sharia or from a law perspective? That's basically the debate. And as you know, we are in a global finance where people are in civil law and others are in the conventional law, other in the common law, and Sharia basically, which combine the feature of the two. So that's the point number one. But from a Sharia standpoint, we take it as a full ownership is required with no debate. Now, clause number two on the IOFI pronouncement is that this uh, what so-called sukuk doesn't represent a debt of receivable. I think we'll talk about it when we talk about the tradability, which means that sukuk representing receivable of debt are not tradable in the secondary market. Are not traded in the secondary market. If they are, of course, and therefore the securitization of pure bait asset and usufruct expect in the following. Number one, meaning that you can trade the pure debt, of course, is no. We'll come later on in the trading. But how to overcome the issue, or what is the exceptions come in? The exceptions is number one, if the financial institution is selling all the asset, including the receivable, that's one no issue, even with discount. Why? Because there is a legal maxims, that you forgive, there is a kind of forgiveness, if the debt is not intended to, because the objective is to sell the corporation. But the corporation has debt, so respectively, it will be sold together. But here we are selling the entire portfolio. We are not selling the receivable at part. So that's number one. It is allowed. Number two, which is the solutions, which is a practice actually in the market, whereby if it is a mixed portfolio where it's the portfolio of the sukuk consists of physical asset, let's say ijara, or equity, musharaka, and mudaraba, and murabaha. So meaning murabaha, pure murabaha is no. With some details, we'll talk about it later on. Number two, if it is mixed with tangible asset with a portfolio or a size of 30%, it is permissible. This is why, if you have a debt portfolio of murabaha, how to make it workable? You have to bring what's so-called additional tangible of what's so-called ijara and create a mixed portfolio, whereby 30% will be physical asset of ijara, the balance will be murabaha, then you will mix this portfolio in one pool, you securitize it, then you can trade in the secondary market. But pure murabaha cannot be traded in the secondary market. So that's the point number two by IOFI. Point number three basically is talking about the prohibitions of undertaking a loan from the liquidity facility under the clause in the sukuk documentation. You will see liquidity facility. This means that in case there is a shortfall on the what's so called periodic payments by the issuer, if there is a shortfall, basically the issuer injects a qard hasan to cover that kind of shortfall, then the qard hasan will be recovered and set off, upon maturity. So basically, it is a practice in some of the sukuk issuance. IOFI didn't like it. Say this one shouldn't be a practice, and this liquidity shouldn't be part of the structure. But IOFI suggested a different method on the liquidity facility by saying that it is allowed to establish a reserve, meaning you can establish a reserve, and also according to the IFSB and also IOFI in some standards, not in the pronouncement, allow also the establishments of the what's so-called profit equalization reserve. So either you create a reserve account or profit equalization reserve with the objective to smooth the return. In a nutshell, what IOFI is saying is that create a reserve to manage your periodical payments in the future, but don't rely on the issuer to inject Qard Hassan if your account of the periodic payments to the what's so called investor is not sufficient. So that's basically the debate here, meaning IOFI in the liquidity facility subscribe to the reserve account and the PER, which is a profit equalization reserve, which is supported by the IFSB as well, and doesn't support the injections of Qard Hassan by the issuer in case of deficit. We have this formula where the shareholders inject capital in case of deficit, but not in the Sukuk. It is in takaful, and it is agreed upon even including IOFI, meaning IOFI allowed the liquidity facility in takaful, but didn't allow it in investment of Sukuk. In the takaful, if the risk fund is not sufficient, is in deficit, so basically the shareholders will inject Qard Hassan to overcome the deficit and keep the risk fund sound. And in the future, they will recover what's so called their capital. So they allowed it in takaful, but they don't allow it in Sukuk. But they provide alternative solutions. Either use the reserve account or use what's so called the profit equalization reserve, or as known the PER. Now also IOFI allowed the distribution of the expected earning, meaning that some of the people say, how come, you start Sukuk today, after 6 months, or after 1 year, normally after 6 months, if it is semi-annually, you start giving already the profit. And we need sometimes, to the business to take off and start to generating income. And sometimes in some projections business, as you know, the first year is always very bad. Actually, when you talk about the ROI, so the ROI and payback money, sometimes it depends on the project. Sometimes it is 1 year, sometimes 2 years, sometimes even 3 years that you can start see. I know some cases, after 5 years, they start to see basically the profits coming. So the question is, how come you distribute and there is no profit? Here, basically, IOFI allowed the permissibility of the distributions of the expected rate of return. And because, as you know, especially in some kind of investment, and it is not related to building a long-term project of 5, 6, 7 years. So they allowed this kind of profit distributions, but it is distributions of the profit which is expected. Now, when it is realized, you will earn it. And at the end of the year, you do kind of calibrations, you do kind of revisions of your account, and either you confirm, you add or reduce, and you balance it accordingly. But the point here is that you can distribute the expected earning before it is realized, similar to the mudaraba. Your mudarib will start working for you as a capital provider. But the arrangement is that his payment is on profit sharing ratio, meaning at the end of the year, upon constructive liquidation, he will get his share. That's the arrangement. That's the mudaraba. Now, but practically how this guy will survive, he needs money for rental, to feed his family, to survive. So what will happen is we will run a kind of a monthly expenses allowance for him. So this is an advance of his future earning, because he has no earning yet. He has no money. When the 1 year finish, then we do constructive liquidation, then we see profit or loss. If profit, arrangement 50-50, he will take 50%. But now we are in the second month. We didn't reach yet 12 months. So what we will do, we will give a kind of an advance allowance for him based on the expected earning projected in the business portfolio. So it is a practice. There is no issue. Practice in mudaraba, project, practice in a sukuk. So there is no issue on that, because this is a very common questions that will be posted. How come, business is not yet making money and you are starting distributing the profit? There is no issue in doing that based on the IOFI pronouncement, provided there is a provision. Similar to the another example, forward lease, same for the forward lease. It is also practice whereby before the building is up, before the house is rent out, you start already collecting the rental. This is in the forward lease, including Sukuk forward lease and normal forward lease. That's a practice, and that's allowed, and that's permissible. But only on one condition. If the building is not up and the project is collapsed, you have to refund back those rentals, advance rentals. So this kind of advance expected earning is a practice with no problem. For point number 4, prohibitions of undertaking to purchase the asset with a nominal value. So this is practically, the pronouncement has direct this issue to the equity structure, mainly mudaraba and musharaka, not the others. Al-wakala bil-istithmar, these three. Mudaraba, musharaka, and wakala bil-istithmar. So it was a criticism by IOF in clause 4 that the repurchase of the under the undertaking upon maturity should be according to the market value, fair value, but it cannot be based on a nominal value. That's the concern of IOF. But at the same time, because it will end up as a guarantee, and as you know, guarantee is not allowed in equity structures, meaning guarantee is not allowed in what's so-called mudaraba and musharaka, and as a result of that, you cannot have this kind of clause. But at the same time, the IOF allowed the guarantee to take place in the equity in case of negligence, in case of misconduct, in case of breach of the terms and the conditions of the mandate. So he's basically required to compensate the nominal value of the capital. But when it comes to ijara, which is clause number 5, the IOF has no objections that the ijara upon maturity to be purchased with a nominal value or on any agreed upon price. And the reason being is that ijara is not an equity structure, so the guarantee doesn't trigger in its structure. And as you can see, one of the most, this is also my view based on my humble knowledge and my humble experience. I always see the strong structures of the Sukuk is ijara. Is the most rich portfolio, number 1, and it is the most resilient structures that accommodate a lot of variations that other structures cannot accommodate it. So the ijara, this is why in the pronouncement of 2008, basically the pronouncement criticized mainly the equity structures, because those years it was a very heavy issuance on the musharaka base structure, precisely musharaka. Of course, mudaraba and musharaka, but the bulk of it was musharaka. And the only structure that was not criticized and has been making exceptions in the pronouncement is ijara. This shows you that ijara, even in the controversial environments, ijara still can survive. So it is a very strong and powerful and resilient structures in Sharia. Now, the clause number 6 is basically talking about the Sharia Supervisory Board putting additional obligations on the Sharia board by saying Sharia Supervisory Board should not limit their role to the issuance and pronounce the fatwa, but they have to carefully review the relevant contract, the documentations, and actual transactions, and also look at the actual means of implementations by the financial institutions, and also ensure the compliance of the operation throughout all the stages, and provide guidelines when they require. So meaning that IOF is expecting from the Sharia board to get more involved in the post-Sukuk issuance. Of course, pre-Sukuk issuance, they are doing their job, but post-Sukuk issuance, so the involvement of the Sharia board is very limited. Only when there are problems, only when there are kind of variations or renewal or amendments or anything, they will come back to the Sharia board. But beside that, they don't get involved in the post implementation. So IOP make a call that they should get more involved. So this is on the first basically sections of today, which is mainly pricing and IOP pronouncement. And we move to the following and the last sections, which is the trading. Um, trading, and hope we are still on time. just any questions, so you can just ask before I move to the next question. At the same time, let me check the box. There is a questions here whether there is a kind of differences between pricing of Sukuk and traditional bond. As we explain here, we are using a method of benchmarking. So basically, they use the same equations, they use the same formula because there is a similarity in the structures. Similar in the Murabaha. In the Murabaha, when we do pricing, we benchmark and leverage on a conventional what's so-called benchmark like LIBOR or CLIBOR or CIBOR or other local or international benchmark. But this is on the pricing only. So you have to distinguish between pricing and structuring. Structuring, there is no benchmarking. It has to be a Sharia compliance end to end. But how much you price it, you may deploy some technical, some mathematics of corporate and equations of corporate finance to be deployed and apply on the Sukuk in order to achieve the price. So we don't see an issue here that leveraging on Excel format and some equations in the corporate finance and the bonds pricing to achieve how much we can price the Sukuk, because as I mentioned, it is just a matter of pricing. Similar, if you if you want to sell, how much? Let's say you are living in UK, right? You're living in the UK, and you want to sell your car. So how much you sell your car? You can't determine your price. You have to look at the market rates. Who are the seller of the cars? All the sellers, maybe 90% of them are non-Muslim. But you are selling, you want to just know how much you can sell your car with the same specification, with the same criteria, with this. So even though the sellers are non-Muslim and maybe the transactions is not Sharia compliance and there are riba involved in those transactions, but you're not concerned about the structure and the process and the SOP, you are concerned about how much this car has a price. Then when you know a kind of pricing, even in the conventional space, so you will be with some basis points up or down based on the discount when you get that amount to sell it in Sharia compliance way. So that's how is even some of the formula in projections, cash flow, determination of the ROI. All these are basically conventional formula, but they have been deployed and benefited by Islamic one with some modification and enhancement to determine their pricing and their ROI and so on and so forth. And we don't see that kind of discrepancy because it's like a math, it's like a physics, it's like an accounting, it's like some equations. Of course, with some modifications and observations to make them more compliant. But we are not talking about the structure here. We are selling just the pricing. So we don't see it as a significant discrepancy. But if we can, in the future, definitely improve our own benchmarking and our own formula. So it will be nice to do that. Let's move to the, where are we? So this is for the question. Let's carry on. I just want to check only the time. Yeah, I think we started 10. Yeah. So let's go to the trading of the Sukuk. Yeah. So after the pronouncement, we have the sections of trading of the Sukuk. So let's talk about the Sharia considerations in trading of the Sukuk. So I try to be also, sorry for that, I try to be brief and quick, just to catching, fighting with the time and the content. So let's talk about the first point. Um, some of the things that it should be considered when we trade Sukuk in the secondary market or we buy and sell Sukuk. Number one, no issue to it is permissible to sell the Sukuk after basically the commencement of the activities. And you redeem them basically based on a common ownership or tangible asset. It depends again on the nature. So there is no issue to trade and redeem Sukuk. That's point number one. Number two, for the trading and or redemptions prior to the commencement of the activity. So that's very important. Uh, it is necessary to observe the rules of the contract of SARF. Why we are talking about SARF here? Because you see, when you raise the funds and you close the subscriptions, there is a gap between deployments of the funds of the Sukuk and starting the activities. I don't think you will receive 500 million today, tomorrow already 100% converted into asset. This is impossible. So we are talking about business plan. We are talking about what's called 10-year projections. So meaning that deployment and the investments and conversions of the liquidity of that 500 million to a specific activity may take time. So in case, but keep in mind, the Sukuk holders have their own certificate in their hands. Now, let's say tomorrow, I hold it today. After 1 week, I need the money. Investors, I hold it today. After 1 week, I need the money. I want to sell it. Can you sell it? Yes, you can. But be careful here. The status of Sukuk is still cash. So meaning that if you want to sell, you have to observe that the nature of the underlying asset is it still liquidity. Meaning you have to observe the SARF rules of the SARF. The SARF apply here. So you cannot do kind of like you are selling an asset. No, you are holding cash. It's like you are holding a check. You are like holding a check. So you have to be careful before the activity. Rules of the SARF may be applied. And there is a standard number one of IOF talking about the trading of the currency. So that standard number one should be observed. Now, this is along with the debt receivable when basically a liquidation is completed. If there is a count of liquidations of the asset, or the asset become receivable. So basically, you will be also looking at the debt portfolio before you sell it. So again, before and after this kind of the state, this is why the certificates behave according to the nature of the underlying asset. If the underlying asset is liquid, so SARF apply. If they are asset, it's very flexible, ready to go. If they are converted to debt, they will be like a debt portfolio, so you have to be careful, meaning that rules of now standard 59 of IOF would be applicable to it. Now, in the case of the negotiable Sukuk, it is permissible also to issue to the issuer to undertake through a prospect of issue the purchase of the market value, meaning that if there are some kind of issuance, and I mentioned it, I think, yesterday, and they are not fully subscribed, so the issuer has the right or is allowed to basically undertake the subscriptions of the balance. But in practice, as I mentioned, in practice, most of the Sukuk are always oversubscribed. The point number two is that certificate may be traded through any means of platforms, any kind of like the crowdfunding. You know, there are some platforms of the crowdfunding. There are some. It could be through apps, through electronic platforms, to stock markets, through crowdfunding listing. So any kind of basically means it's allowed by Sharia as long as it fulfills the Sharia requirement. The following point is that it is permissible immediately upon the issue and up to the date of time maturity, but after passing, of course, the ownership of the asset to the holder of the Sukuk to trade the Sukuk. That represent ownership, of course, of the existence asset or asset to be leased out. You see, when it comes to Ijar, everything is quite flexible. They say immediately upon the issuance, up to the date of the maturity. Why? Why? Because you are basically purchasing upon the upon the issuance or the issuance of the sukuk is the purchasing price of the underlying asset in ijara. So upon the ijab and qabul, you are already having ownership over the asset. Second day you can sell because it's a present asset. But in the case, for example, of mudaraba, you are not buying anything yet. You are issuing a capital. So it is in liquidity status. What to do with the capital, we don't know. It depends on your project. Meaning some money here, some money here, here. This is next week, this is next month, and it goes deployments of the fund in specific project. But so Ijara, the offer acceptance basically is the purchase of the asset. Second day you can sell. So that's how strong and flexible and resilient the Ijara structure. So for the point number two, that it is permissible also for the issuer to redeem prior to the maturity. So it's not necessary to hold the sukuk until maturity. You can redeem anytime. The certificate of ownership of a lease asset at the market price, of course, and at the rate agreed upon, either agree upon or market price. So again, here the flexibility of the ijara, which means the agree upon could be the nominal value of the sukuk, and IOP has no problem with that. But if it is equity structure, so the nominal value will be a problem. Of course, at the date of redemption between the certificate and sukuk holder. The second point, or the third point, is it permissible to trade in security of ownership of usufruct tangibles prior to the contract of subleasing. Here there is a small concern when it comes to the ijara, because you may have a subleasing. So when you do a subleasing, basically, and here when the asset are subleased, the certificate represents rent receivable here. Because here basically you are not owning and getting the rent, you are doing the sublease. So when the sublease creates, so the certificate will represent a receivable rental. So when it's come a receivable rental, so the debt, what's so called the debt will be triggered, and when you want to dispose the certificate, which is basically has a sublease, what's so called criteria or formula. So basically you have to observe the debt, unless there is no specific debt upon the sales, because sometimes you may contract on a 2-3 years, and basically if you take the pool of 2-3 years, the pool of the rental will be receivable because they are not yet due. So the one which is not debt is what is earned, meaning the due date of payments become earned. The remaining, it is basically a receivable. Again, the following point, it is permissible for the issuer to redeem sukuk of ownership of the usufruct of tangible asset from the holders after, again, the allotments and payment of the subscription price at the market price, at the price agreed upon between the parties at the time of redemptions, on the condition that subscription amount is redeemed and not basically deferred. Again, if it is deferred, we are talking about receivable. Just try to be a bit brief on this and quick. Again, it is not permissible to trade certificate of ownership or usufruct of described asset before the asset of which the usufruct to be made available is ascertained, meaning that, in other words, the forward lease sukuk cannot be traded. Only one conditions, because why? What's the difference between sukuk and forward lease sukuk? Sukuk, ijara, and forward lease or lease sukuk, or ijara sukuk, or ijara mawsufa fi dhimma. The difference between the two is that in the normal sukuk structure, normal sukuk ijara structure, or normal sukuk lease structures, the asset is identified. You know the building, that's the building. You know the hospital, that's the hospital. But forward lease, you don't know which hospital, you don't know which building. Forward lease, it is a contract on liability. So the asset is not identified. If the asset is not identified, basically you cannot trade the portfolio of forward lease. The structure of forward is similar to Zamzam Tower. Zamzam Tower is very close to Zamzam lease. For Zamzam Tower in Mecca is a forward lease structures on Al Manafa. But if the, let's say, project of forward lease, let's say it is 3 years. So meaning that within the first 3 years, you cannot trade forward lease. Let's say the building upon the completion of this has been identified, here you can trade it. So that's what the IOF is mentioning to distinguish between forward lease and a normal Sukuk lease. So Sukuk lease, no issue. Forward lease, if the asset is not identified, you cannot trade it unless it is identified. So you can do that. The following point is that it is permissible to trade securities of ownership of service to be provided in specific parties prior to sublease of that services, again, because you have it, so you have no issue, same point that you have. But also when they are subleased, same issue will become, they will be regarded as a receivable to be collected, and here you have to observe the disposal of the debt in case you want to dispose your Sukuk. The following point also is not permissible to trade in security ownership of service and provided to a party to be specified in the future before source from which the service would be provided is identified. I think very close to the first point that we have highlighted. The last point, it is permissible to set up a parallel ijara on a tangible asset by employing the same description. You know, parallel ijara is basically back-to-back contract. And here they allow to set up the structures of a parallel ijara for the underlying asset that was provided to the leaseholder for the Sukuk, and provided the two contracts are independent. And this is basically some of the rules of requirements in parallel. We have parallel istisna, we have parallel ju'ala, we have parallel salam, and we have parallel ijara as well. This is also allowed by IOF, provided they are back-to-back, number one, and they have same similarity on the descriptions, and the most important part, they are independent, meaning there is no cross default on that. Again, quickly, this is the last slide, I guess, on the trading 2 million rules. I hope I didn't overload you. Again, it's permissible for the second buyers of the user flag of existing or specific asset to resell it them, to sell them, so no restriction to sell them. Also, it is permissible to trade the redeem istisna, no issue also to sell them, if the fund have been converted within the period to the istisna, as I mentioned, into assets owned by the certificate holder, meaning the cash has been converted to assets. So basically, you can do that. But if the fund realize are immediately paid as a price in parallel istisna contract, so the manufacturer's item is submitted to be the ultimate purchaser. Then trading istisna is subject to the rules of debt because of the debt creations. The following point, salam cannot be traded in the secondary market, straightforward. Murabaha also cannot be traded in the secondary market. However, trading of Murabaha certificate is permissible after purchasing the Murabaha. Now here, the Murabaha is a bit, you have to be careful on it. So when basically the originator purchase the Murabaha from the original seller and hold ownership at this particular stage, it is tradable, meaning you can sell. Why? Because they own by the originator, number one, they are asset number two, so you are trading the asset. No issue here. But when the originator sell to the Sukuk holder, so that's where the debt is created. So at this stage, after the sales to the Sukuk holders, you cannot trade the Murabaha. Now, again, what is the solution to trade Murabaha? You have to put it in a mixed portfolio with the tangible equity of Mudaraba or Musharaka or Wakalab al-Istithmar or Ijara at 30% level to comply with the standard 21 of IOF. Of course, this is if you benchmark on IOF. If you go out of the box of IOF, there are some practices, you know, like the EDB hybrid Sukuk issuance was 30%, but there are some issuance of IDB as well, which is less than 30%. But the benchmark of IOF is 30% as per the pronouncement of 2008 and per the standard 21. So this is the most important rules that should be observed in the what's so-called the trading of the Sukuk in the secondary market. But besides these requirements, there is no requirements but some regulator, such as, for example, the only rated Sukuk are tradable. So this is some regulations, some regulator, like the Security Commission of Malaysia. So they require that in order to be traded, it has to be rated. Not rated cannot be traded. So this is not a Sharia requirement. This is why we have to appreciate two things. Number one, the Sharia requirements that has been discussed, and other regulatory requirements that could be imposed by the regulators in order basically to ensure the compliance end-to-end. So no Sukuk rated, meaning that would be the decision of the issuer whether you want to rate your Sukuk or not. That's sometimes it is a privacy and confidential for internal informations. Of course, level of attraction to the investor may not be that much. Sometimes governments guarantee are not rated because why should I do rating? Because when you do rating, there is a price, there is a cost. And I'm a government, I don't need rating. So make governments, sometimes government sovereign Sukuk will give you good rating, AAA maybe. It depends which country, you know. And also therefore the subscriber may hold the what's called the Sukuk upon maturity. Let me go to the last two slides. Last two slides before I close the at least session of yesterday or the materials of yesterday. Difference between tradable and non-tradable. So number one, tradable Sukuk, meaning that can be listed in the stock market. They can be treated to buying and selling. The investor will not hold the Sukuk until maturity. And we have example like Mudaraba, Musharaka, and Ijara. Non-tradable, of course, cannot be listed in the stock market. Sometimes they are listed, but not for the purpose of trading. But if they are listed, they cannot be listed for the purpose of trading. Also cannot be traded through buying and selling. The investor are obliged to hold the Sukuk until maturity. Example of that basically like Mudarabaha and Salam. You can list Salam but not traded for listing and marketing purpose and for record purposes, but not trading. Murabaha, yes, but provided you do what we have mentioned, that it have to be in a hybrid structure, meaning that 30% tangible asset. Some Sukuk, their trading are depending on their stage. I think we have mentioned it on the Murabaha. And the hybrid Sukuk of 30%, I think we have already mentioned, meaning that how to make the debt tradable, you have to create a hybrid structure. This is what we have what's so-called hybrid Sukuk structures. And when you heard about hybrid Sukuk structures, meaning that they are trying to mix the debt of the portfolio, receivable of Murabaha or any other debt portfolio with the tangible asset with the 30% in order to create a securitizations which is allow the tradability in the secondary market. The last slides, briefly on the challenges. We have a law regulations, law regulations. Sometimes some jurisdictions, they don't have law regulation. It's a challenge for the regulator to manage the business. Sukuk guidelines, it's difficult for the market player to structure Sukuk if there is no guidelines because there is uncertainty and ambiguity. So they are worried to go wrong. Then they end up in a dispute that they cannot win the case. A lack of active market. If let's say Sukuk issue Sukuk, there is no secondary market. So it will be attractive incentive for me to issue. No attractive market players who may issue corporate Sukuk. We know that sovereign Sukuk is the dominant, but corporate Sukuk is also a very active, what's so-called very active Sukuk that manage the liquidity in the market. Also, not adequate ecosystem, so you don't have end-to-end Sukuk supply chain of Sukuk end-to-end. You may have to leverage on third-party outsourcing, and sometimes it is outside of the country that increase the cost. the infrastructures doesn't accommodate the Sukuk issuance. Ecosystem also, we talk about, as we mentioned yesterday, we have a corporate advisor, we have the SPV, we have the trustee, we have the investment advisors, we have the Sharia advisors, we have the legal firm, we have the accounting firm. All these market players basically should be consist in what's called the ecosystem that help basically provide the support to the market issuance if these are lacking. So the market player find difficulties to go to Sukuk issuance. Lack of incentive, if you don't have a incentive, people will be reluctant. Like for example, Malaysia, they have some kind of incentive on tax holidays, on some exemptions on taxes for some Sukuk issuance, like for example, the Ijara, the forward lease, and so on and so forth. And also, the last point is basically sometimes lack of low demand. People, they don't know what is Sukuk, and corporations, they will not ask for it. There is no halal industry strong. There is no Islamic finance strong. Will create a demand because the buyers of the Sukuk, normally they are takaful operators, they are Islamic banks, they are Islamic pension funds, they are annuity trusts, they are fund managements. If those marketplaces are not in the country, so the demand would be very low because other non-Islamic entity, number one, they don't know what is Sukuk, they are not aware of what is Sukuk, and they are, for them, business as usual, you just buy the bonds. So that's creates basically a low demand, which puts the market at the challenge. That's basically in overall the what's so called the discussions of today. If you have any questions before we take a break. Let me check the box. If there is any question. Then, if not, maybe Raisa can advise us whether it is time to take a break or we shall move to the next session.
Sure. Sir, there is a question that what are the regulatory and financial implications for ideal future Sukuk development?
Again?
What are the regulatory and financial implications for the ideal future Sukuk development?
Well, I think for this one is, if I may ask, answer briefly on that. I think you have to have, more importantly, you have to have a kind of, if we start from scratch, if the questions is some of a country we have nothing, I think we have to start with the master plan, meaning that we want to go for Sukuk issuance, or we want to go not for Sukuk issuance, we want to go for Sukuk industry. That's the accurate term. We are going for a Sukuk industry, so how to go about it? So basically, it has to be a master plan that combine what's so called how to create an ecosystem, how to enhance the infrastructures. And when we talk about these two, we are talking about the law of the Islamic capital market. We are talking about standards and guidelines of the Sukuk issuance. We are talking about when we say Sukuk issuance, meaning end-to-end, including the PTC and all the requirements for submissions, and also the capacity of the stock market to accommodate secondary market activities, also to push the Sukuk from short-term, long-term, and push also the product to the money market to be active as well for liquidity management. And looking at the also educations, because we are talking about the expertise, we are talking about the professionals that will be handling this kind of industry and be part of the game. So they have to, the educations is part of it, the professional providers is part of it, the professional certificate is part of it. We have to basically make sure that accountancy firm who have experience in Islamic finance are there, legal firms with the Islamic finance experience, Islamic capital experience are there, trustee are there, the country accommodate trust law, sorry, otherwise, some country who are going for Sukuk, what they have to do, especially in the context of the civil law, they have to enact trust law. And the trust law would be the legal infrastructures, basically, to be used for the Sukuk issuance. Why? Because we need the SPV. SPV is trust law based. We need the trustee. The trustee is a trust law base. So the trust law has to be there in order to safeguard the interests of the investors, and in order to segregate the asset from the originator in case the originator collapse or bankrupt. So basically the SPV is sound, and the protections and the asset of the investor are protected. We need the Sharia advisors. We need who basically do the endorsement. And we need like a rating agency. Of course, if you don't have, you can still use the international rating agency. And we have the international rating agency, which is based in Dubai, that could be leveraged on if it is needed. And we need also the 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 awareness about this sukuk. If it is if you don't have the local player to purchase, meaning you have no choice but you have to go to overseas. And here, basically, the best way to start with is always the sovereign sukuk. Why? Because the sovereign sukuk always have a very good subscriptions rate. Imagine, you know, Hong Kong, the first 1 billion sukuk that was there during the issuance. By coincidence, I was in Hong Kong, and I commented on that sukuk issuance. I think in 2014, 1 billion sukuk issuance Ijara was very successful, where the subscription was, I think, 4 point something, and they went for a second sukuk issuance for the second 1 billion. And all the subscribers basically are from US, from Europe, from Middle East, GCC countries, Southeast Asia. This is when you go for sovereign sukuk. Basically, you will sell for international market players if your market, local market, doesn't accommodate that kind of absorbance of sukuk issuance. This is why maybe it's difficult to go for a corporate sukuk if your country economic GDP and your economic situation is not that strong. So maybe corporate sukuk will not be the good choice for it. Then you can start with the sovereign sukuk to create the momentum, you know, and the benchmark. So that's a few points I think that have to be observed to have a very comprehensive ecosystem and infrastructures all together. Basically will come hand to hand progressively within a master plan to start, but you have to start from something, you know, even with the sovereign sukuk. So that's my comment on that.
All right, thank you so much. Now we have to take 20 minutes tea or coffee break. Let's enjoy your break. We will meet again after 20 minutes. Thank you very much.
Thank you. See you afterwards. To keep the thinking very focused. Basically, we have one slide on the risk management, and this is the summary of the IFSB, meaning the survey of the IFSB. And the IFSB is basically Islamic Financial Service Board, which is one of the international financial infrastructure institutions. Basically, focusing more on the risk management, corporate finance, corporate governance, and other field of focus, but mainly risk management. So that's their summary that have the highlighted with regard to the sukuk issuance. There are some risks pertaining to the originator, some of the service, some of the issuer, and sometimes keep in mind the originator, the servicer, and the issuer could be the same person, the same entity. And the SPV, SPE, or the SPV is also established by the SPV, sorry, by the issuer and the holder, which are the sukuk. So in a summary, if you want to consolidate these titles, risk management is related or related to the two parties, originators and the investors, meaning the risk of the issuer and of the sukuk and the risk of the holder of the sukuk. This is the summary. But in the breakdown, the issuer could be take a different capacity in its actions of the sukuk. It could be originator. It could be the service provider himself, or sometimes the mudarib in the case of mudaraba, and the leasee in case of ijara, and the issuer that what's so called initiate the issuance, raise funding, and the SPV because he's the one who will establish the SPV, and basically the holders. Now, if you go to quickly on some points, we'll not go one by one, but just keep the main points here in the discussion. If we start with the originator, one of the risks related to that is basically related to the purchase undertaking, which is a binding promise to undertake a purchase back. So meaning that it could be a risk to fail to execute the purchase undertaking upon maturity. That's one. That's number one. And as a result of that, the originator obligation is to make payment in respect to the sukuk asset, as I mentioned, in certain circumstances in case of breaches, because there are some terms and conditions pertaining to the default in case of breach of some terms of condition, it should be kind of accelerations of payment. So that kind of acceleration of payment upon default of the asset in case of what's so-called breach of some terms and conditions could be not be able to be executed, then it will represent a risk. And as a result of that, the originator may need to compensate an equivalent amount, basically, to replace the relevant asset. In case, for example, also of the some distractions of destroy of the ijara assets. Example, you have only one clause in the sukuk ijara related to substitute of the asset, which means that, let's say, for example, let's say you have two hotels, for the sake of discussion. You have two hotels under ijara sukuk. One hotel, 5-star hotel. Now that 5-star hotel, for whatever reason, collapse. Some problems, fire. So asset is not anymore in function. So what will happen? Under the substitute clause in the sukuk issuance, so the originator will bring a different 5-hotel star, meaning that maybe in your portfolio, because this is what I mentioned at the beginning, if you choose your issuance, you have to look at what you have in your pocket and what you have in your inventory. So to be ready. Maybe you are estate business manager, meaning you have properties, hotels, condominiums, and you do retail business, real estate management business, possible. Among them, you have few hotels. Maybe you have 5-star hotels. You put into securitization 2 5-star hotels, maybe, and some commercials, malls, and so on and so forth to create your portfolio. One hotel fire. So what you will do, we will replace this 5-star hotel with the equivalent 5-star hotel. So that's kind of compensations and sometimes of replacement of the asset during the course of the destroy of some of the asset. And this is always important clause. We will find it in the sukuk ijara and also the forward lease sukuk. It's very important. And this one will not make a default in the sukuk, meaning if the asset of the sukuk is destroyed, it will not be regarded as default. Because why? There is a clause to manage that kind of gap. So these are some of the risk, and definitely there are risk mitigations are in place in case some of this happen. The second point is basically the servicer, who the service provider, is basically the risk is that fail to it is an independent, yes, and fail to what's so called execute its duty in its collaborations basically with the SPV or the trustee. Because this service provider or the servicer or service provider depend again, as I mentioned, what kind of sukuk structure that we have. And normally they will do kind of collections payment, distributions payments, and so on and so forth. So it depends what service of they have. If it is a Jara, maybe they have a collections of payments from the rental. So that's the service, meaning that the risk of failures to collect on behalf of the sukuk holder, because sukuk holders are basically institution investors. They just need each SEMI to get their money, but they don't go and collect. Who will collect? The servicer do the collections basically on their behalf, and he will get paid for that. So failures to contribute, and we'll look later on one of the cases, golden belts default. One of the issue is basically the payments rental collection and execution, and later on basically the promissory note of 650 million that wasn't properly executed by the PNB Paribas, during the course of that kind of payment. So that kind of failures represent a risk in the sukuk issuance. The other point is the issuer. Issuer basically could default in the payment issuance, the coupon payment. You have a semi-annual payments, so you may not be sufficient enough to have that kind of payment. The same do golden belt issue and enable to execute and give the rental payment, or the expected rate of return, and maybe your reserve is not enough, your profit equalization is not enough. Even if you want the shareholders to inject money, the shareholders are not have an adequate fund to inject. So basically, default in the servicing of the coupon payments semi-annually depends on the arrangement. So if it fails, basically it have an issue and it creates a risk that could lead to a potential default. The other, and that one basically, if in case of happen, that one lead to the sukuk holder to recourse on the asset. It depends. If it is asset-backed structure, as we mentioned, they will recourse on the asset because they have the asset under the custody on the SPV, and it is held by the trustee. And in case they are what's so-called asset-based, they will recourse on the originator, basically on the portfolio of the originator or the issuer. With regard to the SPE or the SPV, it is of course a bankruptcy remote entity per se, but it has a vehicle, of course, to mitigate the bankruptcy risk, as we mentioned. But also it has the obligations to manage, basically, is something like clearinghouse payments, what's so-called settlements, payments that basically hold the asset on behalf of the investors. So basically, this kind of risk could be faced by them in case they are not able to sell, number one, the assets, at the same time do the settlement to the sukuk holders in case there is a problem in selling those assets. So those are the difficulties, because the one that who is going to sell the assets is basically the SPV with the trustee. So there is an issue of settlements and payments directly to the sukuk holders. On the sukuk holders, the issue will be on the liquidity, whereby they maybe need liquidity, then they cannot sell the sukuk in the secondary market because the secondary market is not active. That's number one. Number two, if the expected rate of return, because it's equity structure, if it is a ijara, it will be no problem to some extent. Only the rate of return risk depends on the performance of the rental, because the rentals, if the business is down, so the rental income will go down, especially in the COVID-19. Imagine COVID-19 problems. You know, the most affected area is basically the tourism, meaning the accommodations, the hotels. So meaning that the real estate income will shrink if you are investing in real estate management. So definitely you are exposed to this kind of risk, because you are not getting the fixed rate expected that the asset underlying are not performing well. And if it is equity, so whatever is expected may not be met. So that's some of the some kind of issues and risk pertaining to the originator, servicer, issuer, SPV, and the holder. Now, if you go to the, we'll go back again to this risk later on when we do the comparison between the risk in the conventional bond and the conventional and the sukuk. We will look at the risk from a different angle. But as of now, which is specifically for sukuk, these are the most key risk factor. Then we will top up and we will add a few of them like credit risk and liquidity risk and others later on in the comparison. Now moving to the sections of documentations. Documentation is very important, basically in the context of sukuk. And the documentations represent represent basically legal agreements that determine and capture the rights and the liability of the two contracting parties and manage all the parties involved. As I mentioned, I'm going to say it's a bit complicated, the process, because it's involved and integrates all the parties, even though at the end of the day, it is investor and issuer, but still there are parties involved, and these parties involved are connected with legal agreement and documentation. But the focus of the Sharia advisors and the focus of the documentations will not be on the different arrangements between these different parts. You know, the focus will be on the arrangements between the issuer and the sukuk holder. That's it. And some related party like the trustee, because trustee is very important. This is what we have, the trustee and the SPV, because there is declaration over the trust. Those all part of the documentation. But I mean, your arrangement with your Sharia advisor, your arrangement with your legal advisor, your arrangement with your rating agency, your arrangement with your maybe investment bank, those are not part of the concern in the legal documentations. The concern of the legal documentations is mainly the SPV trustee, issuer, and the sukuk holder, what kind of documentation and agreement they regulate that. So that's the most important part. It shows the process and what kind of terms and conditions that has been incorporated in that document. I will go here in the high level, then I try to zoom to level one level. Then I will zoom further to a lower level on the documentation. Now, on the high level, the area of consideration in the documentation is basically looking at the terms, the conditions, which may affect the right and the liability of the parties in the legal documentation. Those are very important. So as you know, legal documentations is an enforceable contract. It's determine the rights and the responsibility and liability of the two parties, contracting party, and should be in compliance with Sharia. And again, they are impacted according to the contract that has been selected. If it is ijara, is the TNC ijara. If it is musharaka, it is the TNC ijara. If it is musharaka, it is the TNC musharaka. If it is a mudaraba, it is the TNC mudaraba, and so on and so forth. Terms and conditions and clauses on the legal documentation that are clearly not approved by Sharia, like for example, riba, like gambling, like what's so called gaming, non-Sharia compliance activities, and entertainments, and so on and so forth. Those are basically terms and clauses that should not be in the legal documentations in the form and substance. Like a penalty, like borrower, like lender, like all this basically should be not be part of the documentation. If they are found, they should be basically removed, unless in some cases, some cases in the some non-Muslim country which they don't entertain or recognize Islamic finance, and you have to comply with their legal tax and corporation law. So you have no choice. You have no choice, but you have to comply with that. But at the same time, you have a different set of documentation that provide interpretations. That the interest here means profit, and this borrower here means the what's so called the issuer or the financer, and the lender here means the financer, and so on and so forth. And the penalty here means the compensations, and so on and so forth. So it will be a true supplementary document that interprets the conventional term in the form, but in substance they are Islamic. And some Sukuk issuance notes and PTC, what you will see that there is a clause that they will put it that in case the what's so called the terms of non-Sharia compliance terms have been captured, they are not being acknowledged by Sharia, and if there is a kind of interest be generated as income, it will be waived by both party, meaning that both party acknowledge that they don't want riba, they don't want interest in case somehow in this complex process has been captured in the transactions, because sometimes you go through a global market and you have global purchasers and you have different remittances and different global transactions and listing in Luxembourg's different stock markets. In that kind of complex process, you may touch the riba. So how you will address the riba in that course? So there are some clauses that has been captured, agreed that the party will waive riba in case it has been somehow accidentally or under necessity been agreed upon to facilitate the process of the documentation. So if you have a choice and you are under control, so basically you will just remove it from day one. If not choice, you don't have a choice. So normally you capture it in such kind of disclosure and disclaimer. Terms and clauses in legal documentation which may have an ambiguity and create confusions, like a right to recall the facility, some debated clauses, template clauses. Here, maybe just make it a clarification, because sometimes they mean by these clauses loan, but basically you mean by that the contract. So that kind of clarification to remove the ambiguity, the form and the structure and the legal documentations, the right, the liability of the contracting party in the legal documentation, meaning the nature of the relationship. This is very important, especially in Sukuk, and we have highlighted that if it is Jara, it is lessor and lessee. If it is Musharaka, partner one, partner two, if it is Mudaraba, capital provider and Mudarib, if it is Wakala, principal and agent, if it is Murabaha, is basically purchaser and a seller, if it is Salam, it is what's so called a seller and a buyer, if it is Istisna, also it is a buyer and seller, and the list goes according to the structure. Combination of the contract is very important, because we have a set of transactions, we have a different set of relationship. Like I just mentioned now, the originator could be himself the mudarib. The originators could be the issuer. The issuer could be the guarantor. The issuer could be the lessee. So it may take different positions. How to combine, how to design the contract to ensure that every contract is a standalone on its own, not connected with the other, because you may use a different hat. You have to make sure that your course of actions based on contract basically doesn't mix with the other one, similar to a parallel contract. We mentioned we have a parallel istisna, we have a parallel ijara, we have parallel salam, we have a parallel ju'ala. It is allowed, but you have to ensure independency. Same, you can be a purchaser. At the same time, you can be Asian. At the same time, you can be a guarantor, but you have to make sure that risk and right and liability, responsibility, doesn't mix with the others. So this is very important, and it is allowed according to the IFRS standard, and it is a practice in the market, but it is carefully designed to avoid a proper, and IOP has a standard on the combination of contract, meaning how you combine the contract in one facility. This one, you have to observe the combination of contract standard. And the other point is basically the sequence of the executions, and this one become a very important, especially it is a part of the requirements of some of the Security Commission that you do the executions, and the execution has to be signed off by the Sharia advisor to make sure executions is according on. And we have highlighted, I think yesterday, the importance of the executions, because the nature of the contract and the course of actions require a sequence, proper sequence, in order to ensure compliance, meaning that you have to buy before you lease out, you have to buy before you sell. Because the Prophet ﷺ said, "Let be Malaysia index," so you cannot sell what you don't have. You have to own, then you sell. That's the important. That's why the pronouncement of IOP 2008, first clause, emphasizing on full ownership. That's the important thing. Meaning, before you act, before you do, before you list out, before you sell, before you transact, you have to make sure you have a full ownership with evidences on the asset in order. Otherwise, you may have a problems on the ownership, and the domino effect will take place, meaning that whatever comes after that will not be valid. So executions of the sequence is quite crucial and important. Let's go to one level lower, which is the documentation in Sukuk. And we try to go in general first, a general approach on the documentation, because as I mentioned, documentations could be Sukuk document, it could be Ijara documentation, it could be Musharaka documentation, it could be Mudaraba documentation. So if we go on a general approach first, we have some important documentations. The first one is basically the subscriptions program, or we call it Sukuk Issuance Facility Agreement. And this one basically is like the master agreements. It has a recital. Recital will portray basically the scenario and the history of the facilities, like an introductions. You have the definition section that provide all the definitions of the facility and have all the agreements and execution security descriptions of the parties. Then we mention here, although Sukuk issuance may be structured as a Ijara or Musharaka transactions, as the case may be, the drafting of the documentation in some country will still reflect its legal status as what's called a financing facility. Here it goes back what countries, what's the approach of each country. But that's the one of the point to be looked at. The other box that you see here is the common term that normally captured in the facility agreement issuance. Then we have the availability period, the purpose and facility descriptions, the agreement to subscribe, payment, and primary subscriber, the utilization of the proceed, condition, precedence of availability of Sukuk, the security if applicable, the redemptions of the Sukuk, representations and warrants, and positive, sometimes affirmative, or the positive and negative covenant, event of default, dissolutions, event, and governing law. That's basically the main, and each sections has basically a description on each one. The second documents, which is normally we call it trust deed, and the trust deed is again govern the trustee. Govern the trustee because normally you have a declarations over the asset as a trust by the issuer in a favor of the Sukuk holders, and that one will be on the SPV that is being created, managed and handled by the trustee. So we have such documents that you call it a trust deed, that you may see it in the documentation. Some countries I mentioned here, they may not recognize the trust, like the civil law. They don't have this concept. It's only in the common law. So they don't have choice, but they have to enact trust law in order to facilitate the Sukuk issuance. But sometimes they may do it without. I think, if I'm not mistaken, Maldives has issued, I think Maldives is a civil law jurisdictions, and they have issue sovereign Sukuk, and they don't have trust law. It's a risk, but they did it. Meaning you recognize, at last you recognize the issue, you appreciate the issue, then you put some medications because you don't have maybe time to call for trust law, go to the parliament, issue. It may take maybe years to finish, and you want the Sukuk issuance to be done maybe this year. So what you will do, you just acknowledge the risk, convince the investors, um, and if it is private placement, it will be much easy. It is for public, you have to do your marketing and convince them. But if you have a trust law like the common law, so you don't have a problem. So number one, the trust deed or trust deed basically is a set the terms and the conditions by the trust, by the trustee, for the benefit, as I mentioned, to the investor Sukuk holders, which is normally we call a declaration of trust over the asset in favor of the Sukuk holders. It have what's so called trust deed. Main role of the trustee is to act on behalf and for the interests of the investor for the Sukuk issuance. Then you have qualifications of the trustee, the requirements under the relevant law. Of course, if you have a law, so you have to follow the law. Like here in Malaysia, we have trust law and we have trustee companies. So basically, they are governed by this trust law. But if you don't have, so you have to create a guideline or something like that. And also example that the trustee is permitted by law to act as a trustee in respect of the Sukuk or conventional bond structure, something like this. And the trustee shall act upon instructions of the investor. So basically, because they will represent the interests of the Sukuk holder, even though the asset is under the SPV, but the trustee of the SPV is the trustee. So that's a very important point. Again, act upon the instructions of the investor, exam, declare an event of default, dissolutions, whatever things. So basically, the negotiations will be between the investors and the trustee to act, you know, against or recourse against the asset or with the issuer. This is in case of the potential default will be negotiated. This is the trust deed. Now, what are the common terms of the trust deed? We have holding of a benefit of the transactions, document, property acquired under the issuance of the Sukuk by the trustee, and possessions of the amount received upon trust for each and every Sukuk holder. Again, face amount, the status of the Sukuk, trading and redemptions, from them payments, redemption, and manner payment, payment and representations. If there is any kind of a city of global certificate or exchange of those Sukuk denominations and the form of definitive Sukuk title and ownership. Again, covenant to pay, face amount of the Sukuk, cancellation of the Sukuk. This is some of the terms that you may see, and they will be captured. Then you read it. It is a legal documentation, but it is driven by a trust concept. And its bottom line declaration of the assets by the issuer over the identified asset in favor of the Sukuk holders, then the responsibility of the trustee in his course of actions, which capture this sum of the points. Of course, you may add, you may reduce. It depends on the practice of the market. It depends on the agree upon stipulated term and the conditions that would be added, because here we are talking about risk mitigations and we are talking about the interest of the Sukuk holder. And of course, it will be some kind of win-win situations, market practice, benchmarking on other documentations, compliance with the law of trust. All these basically will be captured in the trust deed. Now, the third, basically, document that you may see is is basically depository and paying agency agreements, because there is a money, there is a payments. So we will see a kind of terms that allow issuer to appoint agent for the purpose of issuing, registration, lodging security into the agency, and automating the payments of profit and maturity proceeds. All this will be arranged. The depository shall hold the global certificate in its custody and on behalf of the trustee and investors, because this is some of the payments done by a third party, even though it is collaborated with the trustee. And also provide the appointments of the depository and paying agents, obligations of the issuer and the trustee, obligation of the depository, payments, payment profit, principal amount, and trading certificates, etc. Some what so-called terms and conditions that govern the depository, the paying agents, the paying money, the deposits, profit payments, and so on and so forth, will be captured under this third agreement. Now let's go for a level, one more level down to zoom into one. I think I just selected Musharaka on here. Yes. I just pick up Musharaka because, you know, this legal documentation may take I mean, a long time. We can't, I think, we have over, I told you, 14 sukuk. We can't present one by one. So we have selected the Musharaka. Musharaka as an example. So we have moved from the general aspect of documentations to the basically general concept of the sukuk. Now we try to zoom into Musharaka agreement. So Musharaka agreement basically is a kind of partnership. It's a kind of joint venture between the investors and the issuer. That's basically the concept. See, as I mentioned, we have to define the contract. It is a partnership between the issuer and the investor. Meaning the investor comes with money, issuer comes with money, together they invest together, they share the profit. This is the concept. Meaning the money doesn't come from one side. Yes, you may tell me it is a sukuk issuance. I will say that's the portion of the investor that has been raised in a form of sukuk. But there is other portions of the issuer that together will create a portfolio of a joint venture to invest the money, then they share the profit. That's the concept of the sukuk. It is the same ijara that you know it. Sorry, same musharaka, do you know it? It's the same rule, same definition in the book. Same musharaka for home financing, same musharaka for project financing, same musharaka for sukuk. It is the same contract. It doesn't change. Whatever you run in musharaka, it will be applicable here. Whether it is sukuk, whether it is a home financing, whether it is a financing of machinery, in the same for ijara. The same rules of ijara of your apartments, if you are doing some ijara business, same rules will be applicable to sukuk, to car financing, to home financing, and so on and so forth. So it doesn't change. What changed? The instruments, the environment, the parties, the executions, some guidelines and standards that create an ecosystem of a sukuk industry. That may change, yes, and impact a little bit the way you do it. But if you go to basic, musharaka is two parties coming together with capital invested, share the profit. Same for sukuk. But the only thing is that sukuk, they don't come one by one. They come together through the trustee to basically raise the funds. That 500 million will be capital one. Then we talk to the issuer, where is your capital? Then he will identify his business, but the only thing, the practice here, we're talking about the practice, huh? The practice that the issuer will not come with cash, will come with business. We need a business which has a value, because musharaka is allowed to be in kind or cash. Meaning one give Just give for a normal 101 musharaka. One will come with 1,000 US dollar, or let's raise it a little bit up. One will come with 5,000 US dollar. The other one will come with a second-hand car. The other one will come with a new brand iPhone. The fourth one will come with a piece of gold. Is this musharaka? Yes, it is musharaka. It's not necessary to be cash. It could be kind. But what is important to be commingled and mixed in one single portfolio. And evaluations of all this technique, modern technique, to be taken in place to form the joint venture. That's the same. So practically, the issuer will not come with the cash, but will come with the business portfolio. Then the Sukuk, the money, 500 million, will be injected, commingled with the identified business. Then they invest together. Then they share the return. Okay. So there may be arrangements for the collateral and securities, and there are maybe provisions to effect that profit sharing issue will be in the favor of the investors. Meaning here again, when there is a guarantee, when there is a collateral in equity, so it's an alarming issue in Sharia. When there is a meaning that you are in discussion in Sukuk, maybe Sharia advisor is sleeping, discussing in Musharaka. The Sharia advisor is sleeping, but when you say guarantee, he will wake up. So it's like a alarming term. So he will be sleeping. When you say guarantee, he will wake up. So the word will wake him up. So guarantee in the equity is very crucial. That's why it has to be very carefully drafted. Meaning that if it is by the issuer, it will not be permissible because it will be converted into guarantee in equity. If it is a third party, no issue. If it is within, but with conditions tied to the negligence, misconduct, breach of term and condition, no issue. It is allowed by Alfi as well. So it depends how you draft the security. It is allowed to be there, definitely, but you have to be carefully look at. Now, some of the common terms, specification of the musharaka, checking what this kind of musharaka, what kind of business venture, contribution of the capital by the investor, how much by the issuer, how much appointments of the manager. And in practice, the manager of the musharaka is always the issuer. Not third party, is always the issuer. Similar, the leasee of the Sukuk Ijara is always the issuer. So this is in practice, but it could be third party. But I'm talking about the practice. Practice has no issue with Sharia. Provisions for profit and loss sharing has to be there. Provision of profit distribution mechanism, how to do the profit, a possibility of waiver, channel of for distribution if it's excess of and above the expected rate, meaning that sometimes very often found in the investment, whereby if let's say the rate of return is 5, so you are targeting 5. So normally you will see close any rate above 5% will be given as incentive to the manager, meaning the manager did a good job. So we're expecting 5. Alhamdulillah, we got the 5. So anything above the 5 is yours as incentive for the manager. Normally you will find this kind of clause, dissolutions of musharaka. Other terms which are a bit somehow essential for the musharaka agreement may look at the musharaka partners, who are the partners, the agreement to enter into musharaka contract, contribution of the capital by the musharaka partners, and respective proportions, how much that one, maybe 90%, 10%, 60%, 40%, specification of musharaka ventures, manner of profit of loss, as we mentioned, and dissolution. This one have been mentioned already in the common terms. Additional to that, you may have detail of the profit distribution mechanism. You may have a kind of the frequency of the profit distributions, appointment of the managers in the musharaka, the waiver, the tanazul, the reserve, the profit equalization reserve, in case it's false, what the course of actions, and so on and so forth. So these are basically clauses that you may find it, and there is an agreement to address it. You will find also in the musharaka what's so called management agreement. Management agreement basically will be entered separately between the investors and the manager, the investor and the management for the musharaka. And this management will be basically submitted under the musharaka agreement. It's like agreements between the investors and the issuer. Why the investor and the issuer? Because as I mentioned, they have different hats. So number one, the issuer is a partner. Finish. Now they will say, who will manage our investment? Then the issuer will raise his hand. Me, I will do it. Oh, okay. So you are partner, you want to be manager. Fine, we don't have problem. So we will appoint you as a manager. So this is why we have a management agreement. Similar, if you have two partners in a company, then they will say, okay, we'll start doing business now. Good, good. We need an accountant. Or is it? Actually, I'm professional, I'm an accountant. I can be an accountant, you know. So what they will do, they will contract with him to be an accountant of the company. So he has two hats. One is a partner, the other one is an accountant. Let's say restaurant. They want three people have a restaurant partnership. Okay, Alhamdulillah, let's start business. We need chef. We need chef who know how to cook. We need the cook. One of them say, you know, I have experience in cooking. I can be the chef, you know, I can be the cook. Oh, okay. We'll appoint you as a cook. So meaning that he will take a fixed salary on a monthly basis as a cook, and he will take a dividend at the end of the year based on the profit generated by the partnership. See, this is also accepted by Sharia. So you may have two hats, no issue. It's the only how you draft the agreement and how you to combine with them and how you ensure the independency. Why independency? Let's say you are being appointed as a cook. Then your food is lousy. You don't know how to cook. What the partner will do? Will terminate you. Okay? Terminate you as what? Terminate you as a cook. But you are still partner. Because there is no connections between the appointments as a cook and being a partner because they are two different contracts. Same here. You are a sukuk issuer and you are breaking the sukuk to be a partner for you. Then you tell the sukuk holder, you know, I would like to be the manager of the business because I know better this business. Okay, we hereby appoint you. Then they will run the management. Some of the common term in the management is basically appointment of musharaka, a management scope of the musharaka, you know, the receive capital contributions, apply the fund of musharaka, even remunerations, how much we give you fixed or something, the terms, durations, terminations, all this, we will deal him as an independent entity. If you comply, we will say, if not, we terminate you. Very simple. Now, the third agreements in the musharaka, common one is the purchase undertaking. Purchase undertaking is that upon the maturity, what happened? Well, the issuer will hereby undertake to purchase back the portfolio. And in the ijara, the lessee or the issuer will purchase back the asset. Meaning purchase back his hotel, purchase back the hospital, purchase back the land, something like this. So in the musharaka, not necessary, but maybe part of the security arrangement for musharaka, maybe an issue of IOFI pronouncement. We are not saying it is an issue in IOFI pronouncement. IOFI pronouncement, as we discussed it just now, is a having a purchase undertaking with a nominal value. That's the problem with IOFI standard and requirements. But having an undertaking to buy it with a fair value, market value, IOFI has no problem with that. So that's the issue to be very clear. You may have a purchase undertaking in the musharaka, but basically there is no issue from the IOFI perspective as long as you purchase it on a market value or fair value. But the only issue if you use the market value, that may tantamount to a guarantee. So basically, the issuer may provide an undertaking to purchase the asset of Musharaka venture from the investor upon the happening of specific. So it could be dissolution, it could be default, or it could be maturity. So it depends. It will be highlighted in the agreement. And as we mentioned, see, according to the IOF, it is market value. Some comment of this kind of term is specific event for application exercise and the taking price when manner of the application is exercised, execution of the sales, at the time of payment, the exercise price, and so on and so forth. This will be captured basically in the sorry, in the agreement. Yeah, this is the basically first item, which is basically the risk factor in Sukuk, which include risk and the documentations. Any question before I move to the second point, which is related to the takaful product, which is related also to the risk because it's about protection. Before that, let me go to the chat box if I found anything. So far, there is no question.
Sir, there is a question that what kind of assets can be used as assets in the structuring of Sukuk?
Again, you are breaking. Can you say it again?
Yes. What kind of assets can be used as underlying assets in the structuring of Sukuk?
If I capture what kind of asset that can be used in structuring of the asset, is that correct?
Yes, sir.
Yeah. Well, actually, as I mentioned, this is again going to the same point I have highlighted. It depends what's in your pocket, what's in your inventory, and what kind of business you are doing. Some of them are very straightforward. If you have, for example, hotels, I think your hotels will be the underlying asset, and the best way to do it is Sukuk Ijara. And the same goes if you have hospitals. If I take the ministry to be much easy, if you take the Ministry of Transportation, so they have the airports. In some countries, they have one or two, three airports. They have ports. Sometimes they have one or two ports. They have what's so-called aircrafts, aviations, airlines. So meaning you can securitize ports, you can securitize what's so-called airport, you can securitize aircrafts. How many aircraft you have? Boeing 777. Now, more importantly, especially in the transportations, you can securitize the benefit, meaning the user fact of the aircraft, meaning that you don't sell the aircraft, you sell the right to sit on the chair of the aircraft. You don't sell the chair, you sell the right to sit. That's what you sell, that's what you securitize. This is why when we do securitization, we don't look at the value of the aircraft. No, we look how many seats you have. 300 seats, okay. Then how much is the seat? Depend on destination. Let's take Dhaka to Jeddah. How much is the seat? Let's say, for the sake of discussion, 1,000. 1,000 times 250, maybe the aircraft 250 or 300. Then how many trips in a week? Or how many trips in a month? How many trips in a week times 4? How many trips in a month times 12? How many trips in a year times 10? How many trips in 10 years? You are securitizing the right to sit, not the chair and not the aircraft. So it depends again. So you can innovate. And sometimes a service, as I mentioned it also yesterday, providing education. Providing educations, providing training. You can securitize that portfolio. If you have a contract, for example, with the university or government university to provide the training for 10 years for I don't know how many thousand students and this, then you get a volume. That volume is could be securitized. So again, it could be services like education and training. It could be user rights like the benefit of the asset, hotel, for example. So what you do, you take how many hotels, how many rooms, how many months, then you will securitize 10 years of hotels. You don't securitize the hotel itself as a tangible, but the right to occupy the room, how much it is. That's what you securitize. We call it Sukuk al-Manafi', Sukuk of benefit, or Sukuk of Usufruct, which is part of Ijara. And if you have tangible asset, of course, you do the tangible asset like port, like, for example, transportation, you have different trains, how many trains you have. So you have this kind of assets, that's what you should do. And in the case of yesterday question also, you may have lands, and this land could be productive land. So it could be securitized. It could be what's so-called cars, service taxi cars. You know, now what we have in a city, you have like a Grab, you know, you have taxis providers, one company, maybe they have 1,000 cars in the city or in the country, 1,000, 2,000 cars in the country. So you don't securitize, you have two options. Either you securitize the cars or you securitize the service of the car for 10 years, 15 years, and so on and so forth. So this kind of thing, anything can be securitized. IPs, patents, tangible, non-tangible. If you don't have anything from this, so you move to the investment. The investment is basically musharaka, mudaraba, and what's so called wakala. So meaning you raise capital to invest the money and share. If you don't have something to invest and you don't have asset, tangible or otherwise securitized, maybe you have something to buy and sell and make profit. Then you go to Salam, then you go to Isas, then you go to Salam, or you go to Murabaha. If you don't have something to buy and sell ready, but something to build and sell, then you go for Sukuk Istisna. Then if you don't have something to build and to sell, but you have something to build and lease, then you do forward lease. So the point here is that in whatever economic sectors, in whatever kind of asset that you have in pocket or based on your expertise in area of specializations, the Sharia give you the solutions to select the appropriate Sukuk structure to be convenient. This is why before the issuance, a discussion will take place between the issuer and the lead arranger or the advisor and the Sharia advisor. You know what is the best. This is what I have, this is what I have. Then they will find out the best course of action associated with the risk, what kind of risk you have, whether this is the risk, is it really risk or appetite risk or not. And based on that, you take a course of action. So by that's the answer. It's a very wide, it's very flexible. It's upon the conveniency of the issuer. It's what the issuer has, kind of assets, what's the expertise of the issuer. And based on that, basically, the recommendations and the selection of the Sukuk will be recommended. That's the, I think, the answer for these questions. And maybe we carry on the second section since we still have time. I think we have around 30 minutes. Let's at least move to the sections, if no further questions, to cover the following session. Following session is talking about, so we have talked about risk. Now, how to cover the risk through takaful, And sometimes the takaful comes in a form of guarantee. It depends. Sometimes takaful, as takaful we know it, but sometimes they don't go for takaful, then they go for guarantee. So it's more practical, they go for guarantee. Takaful will be on the underlying asset, especially if it is ijara. So what is the takaful? Basically, according to the definitions of IOFI standard number 26, basically Islamic insurance is the agreement of a person's exposed to certain risk to avoid damage arising from this risk by paying contributions on the basis of the obligations to donate. And it is consists of an insurance funds that is legally personally ruling, that has independence, financial liability. If I put, I mean this, you have the definitions, you have the write-up. Let's rephrase it in a very simple illustrations and definition. So basically, the takaful is a kind of scheme of protections, is a kind of coming together to cover a specific risk. And this coming together is based on mutual cooperations, help and assistance, whereby we agree all together that we have a commitment to donate a specific amount in a pool of funds. Then we appoint a wakil, who is a takaful operator, to manage this fund on our behalf in case of risk, injury, accidents. Then he will compensate the person who's suffering that kind of damage and incident. And for us, we will have a commitment to donate. So that's basically the concept. The participants are the contributor. The money is donated based on tabarro, donation, and the takaful operator is the agent representing the contributor to manage the fund on their behalf. In terms of collections, administrations, in case of claims, they do before that they will do the underwriting, and in case of claims, they do the claims administration, then they pay the compensations, and of course, since it is under the central bank, it will be regulated under the supervisions of the central bank, meaning law, regulations, guidelines, standards, and so on and so forth will be applicable to this takaful. It is what everyone knows in the conventional space, insurance. It is known that insurance, for us, it is known as takaful or Islamic insurance. IOFI standard 26 use the terminology of Islamic insurance. Other markets, they use the terminology of takaful. Takaful / Islamic insurance is the same concept. So takaful, as I mentioned, it's based on fundamental like mutual responsibility, mutual assistance, and cooperation, and mutual protections and guarantee. And the objective of takaful basically is about protections, investment, and saving. But number one comes in is the protections. Now, these protections could be based on a different type of product. We have two major products. Number one is the general product. This general product is basically doing protections for losses arising from any danger, accidents, flood, burglary, and other incidents that may happen. And this has one annual contributions. It is renewal annually. And the second one is basically the family takaful, which is known as life insurance, family takaful, which is related to the basically income protections mainly, and goes on a monthly contributions, and it has a one long-term tenure. It is not like the general you renew every year, like fire or insurance for whatever incidents, car accidents, road tax, all this. It is a yearly renewal, but family, it is normally a long-term policy with a commitment of a monthly contribution. And each one, of course, they have a different product that has been designed to address the risk of this participant. Now, when it comes to the takaful, it is provided in Sukuk, sometimes in a form of takaful, because the takaful has the concept of protections. So two choices, either you build a concept of takaful within the Sukuk structure, or you leverage on third-party providers to cover the some issues and accident in the takaful, or it goes also to cover some of the asset of the ijara, because ijara also, they are by default actually have already the takaful policy before the sukuk issuance, because it's a business as usual. Every hotels, every hospital has a takaful policy on fire. And practically more, they have a tendency in practice on doing guarantee, not on takaful. But both options are open to the sukuk issue. Now, for guarantee on musharaka, I think the pronouncement of IOF 2008 came back to us, meaning that we cannot do guarantee for musharaka or mudaraba unless it is from a third party, or if it is within, it should be tied to negligence, reckless omissions, and basically misconduct, breach of the term and conditions. So that one is allowed. Other than that, basically equity is not allowed. Now, in practice, some of the country jurisdictions, what they have, they establish entities and organizations who are specialized, which are specialized in providing guarantee and providing credit enhancement. And one of them is basically this Dana Jamin. Dana Jamin is a national entity. It's a government-linked agency based in Malaysia. What they do, they provide, it was established anyway in 2009, to be the financial guarantor that provide guarantee for the sukuk and bonds, both of them, and also provide the financial guarantees, insurance for bond and sukuk issuance in Malaysia. And they have three products, mainly financial guarantee insurance, which related to the credit enhancement, investor guarantee, which is optional investor protections for bonds and issuance, and financing facility guarantee, which is credit enhancement for financing facility. But what is important for us is basically number one, which is the credit enhancement for the bond and sukuk, precisely for sukuk. So meaning that if you have a sukuk structure, and the sukuk have not a very high rating because of potential risk, so the Dana Jami come as a third-party providers guarantee to address those issues. Then it creates and provide what's so-called credit enhancement. Then the rating will move up. Then it will have a very good credit, which help in the marketing and selling the what's so-called selling the sukuk. So normally, when there is a guarantee in the business that you are running on a daily basis, normally you go to bank, to finance company, like we have also in Malaysia, GCC, which is a guarantee corporations provider for normal business, SMEs, and so on and so forth within the market. But Dana Jami is more government agency specialized in the Islamic capital markets, specialized in providing guarantee for sukuk and bonds. So it is more specialized, and they know better their business compared basically to other provider in the market that provide guarantee for the SMEs. So when it comes to the sukuk issuance, you are a sovereign. If you have a sovereign sukuk, you don't have problem with the credit enhancement. You just go directly. If let's say you have a sukuk ijara on the quality of the assets and your cash flow and your projection is good, you will get a good rating. But if you have an equity and basically and it is asset based, not asset backed, and the financial standing of the issuer is not that strong, the rating may be low. So the Dana Jami will come as a provider to do kind of guarantee for any potential losses that may incur in the duration of the sukuk. Then, because of that guarantee, so the rating agency like Mark, like RAM, like Standard and Poor, like Fitch rating, like Standard and Poor, like Moody, those will provide a very good rating for you. Then it will be easy for you to market those products. That's basically in practice. This is the first section. If you have any question, this is just um, covering the takaful. And let me go to the chat, the box first before I move on. If any questions here, otherwise I will just, okay, no questions unless you have a question. Otherwise I cover some of the slides within the time given to just ensure that we are covering the material. Now what we are talking about is utilization of the sukuk, and we'll be covering the sukuk as a tool for liquidity management. Then we'll talk about utilization of the sukuk. Then we take the sukuk as a retail product. So we see how much we cover because we have a limited time, less than 30 minutes. Maybe we can cover some slides before the break. So talking about sukuk liquidity, definitely when you talk about sukuk, the liquidity will come as one of the very important related subject connected with sukuk. Sukuk have been used in the liquidity management as a tool for Islamic finance, for Islamic financial institutions, and also for other big organizations, because it is an investment instrument that generates return and at the same time used for liquidity management when needed. And here we have some of the sukuk issuance on short term, because sukuk issuance could be issued in short term, medium term, or long term. If it is issued in a short term, normally they will be in a money market for liquidity management purposes. And if it more than that, so it could be also used for liquidity management when needed by selling them in the secondary market. Meaning less than 1 year, it is liquidated and traded in the money market. If it is more than 1 year, it is traded in the secondary market. Now, if the secondary market is active, of course, provided it is active and is very liquid, it will be good. But again, this is why I mentioned in responding of one of the questions, is the infrastructure is very important. Infrastructure is very important because when you have a very good infrastructure, when you have a very active primary market, when you have very active secondary market, so you have a liquid market, meaning liquidity will not be issue. Otherwise, you may have a risk, liquidity risk in the sukuk issuance. So it depends how active your market. So again, issuance of a short-term sukuk in the money market for liquidity management purpose is there. There are some issuance. Issuance for a long-term sukuk, for especially for takaful operators and pension funds. This is why actually the pension funds and the takaful operators are actually a bit having some challenges because there is no sufficient long-term sukuk, especially takaful operators and pension fund. They like long-term sukuk. They don't like short-term sukuk because there are a lot of available short-term sukuk, medium sukuk, but long-term we don't see much. And why the takaful and the pension funds, they have long-term sukuk? Because they have a long-term commitment, a long-term liability. You know, like the annuity scheme in takaful, it's a kind of payments until the person dies. And some of the policy, family policy, it is at the age of 70. Some of them up to 90. Pension funds, sometimes until you die. So it's not short term, it is a long term. So they need to structure their income and the projections flow to manage that kind of schemes by leveraging on a long term instruments, and basically one of the very good instruments that they can use is Sukuk. But the only thing is that we don't have much long-term Sukuk. Most of them is a medium, short-term, medium size. But there are some, but not many. Again, issuance of also tier one, tier two on the Sukuk for capital structure market. This is for Musharaka, which is a good because you know the Sukuk issuance on Musharaka on the equity was a bit reluctant because people they like fixed income and secure structures. But when the Basel revised, tier one and tier two capital in the banking, and the requirements is compatible basically with the Musharaka and the Mudaraba, we start to see some Sukuk issuance in a tier one and tier two, and that's a very good also what's so-called initiatives by some banks that encourage the equity issuance in one hand, and number two, it is for liquidity and capital structures purposes. So it enhances the what's so-called Sukuk issuance market. Now, if you go at the international level, we have this international liquidity management, which is again one of these international Islamic infrastructure institutions that serve Islamic industry at the global level, similar to IOFI, CIBAFI, IFM, ICRA, ILM. So we have a few, Alhamdulillah, international rating agency also. We have a few that basically they are regarded as a global players and regarded as the international Islamic infrastructure financial institution that support Islamic finance globally. One of them is ILM. ILM is basically liquidity management providers. It is a liquidity management providers and provide liquidity management through the issuance of Sukuk. Since basically the inaugurate of the issuance of 490 millions have been issued within 3 months. I mean, Sukuk is a short term, and the International Liquidity Management Program now has outstanding of 3.51 billion Sukuk issuance. So imagine this 3.51 outstanding Sukuk issuance has been issued for one purpose, liquidity management. So this is to show you the importance of liquidity management in the market, number one. Number two, to show the contributions of the Sukuk issuance in fulfilling the gap of liquidity in the market. And as you can see, it is not local, it is cross-border transactions, meaning that it is, yes, what's so-called based in Malaysia, but similar to IFSB is based in Malaysia, ILM is based in Malaysia, IOFI, CIBAFI is based in Bahrain, FMM, International Financial Market, is based in Bahrain. International Center for ICRA, for International Center for Arbitration Reconciliation, is based on Dubai. International Rating Agency is based in Bahrain. So some of them in Bahrain, some of them in Dubai, some of them in Malaysia. But bottom line, they serve the international financial market or the Islamic finance industry. So imagine 3.5 billion, and the demand is there. And this is not a statistic because this is not really updated statistic, but what it is updated actually. But what I'm trying to say is that the momentum of the Sukuk issuance still there and demand still there. 51 billion outstanding Sukuk represent a small contribution of the Sukuk that could be contributed in this space. Of course, this is over and above the local issuance. Like, for example, if you take Malaysia, Malaysia has Sukuk issuance which are designed for liquidity management purposes, meaning the 3.5 billion is above of what each country is offering. Each country is issuing Sukuk for a local liquidity market. And this is all above because this one are international market players. It is not serving one country. Now, the second point that we would like to talk about is basically the retail market. And the retail market here is quite interesting when it comes to Sukuk, because Sukuk is the number one, I may say, very complex financial instruments, very also complicated process for the issuance and dealing, and the denominator of the Sukuk issuance is quite expensive, and the purchaser and the investors practically are Islamic banks, conventional banks, the capital operators, pension funds, treasuries, government treasuries, big corporations treasuries, and so on and so forth. So meaning that it's the game of the big guys. But there is a tendency now to drive the Sukuk towards the retail market, which is a very good initiative and shows the potential of Sukuk as well. That Sukuk will be in the future, it started now, but it will be more and more in the future similar to unit trusts. Unit trust, mutual funds, everyone can get it from the market. And it's available to the retail market. The stock market also now, it is accessible by everyone and easy to access by individuals. But in the past, who can access the stock market? You know, it's like a ghost. But now everyone, stock market in his iPad or mobile. And you can buy directly without a broker, whatever stock you want from the market. So that's how the evolutions of the business and the investment is coming up. And I think it is the same for Sukuk. Sukuk, it's a product of the big guys, but now it's coming lower and lower to be in the retail market with the objective to redistribute the wealth to the society, number one. Number two, to ensure the financial inclusions and to benefit basically the public and the community at large. So retail market means that individual can purchase in a very simple definition. Individual can purchase, and there are some initiatives. So retail firm market was also introduced in Malaysia. If I take the example of Malaysia, it has been introduced for the message to allow the access of the public to this investment portfolio, investment product. Because, you know, keep in mind, investments mean you are making money. So the idea is that why we keep Sukuk for big guys to make money, why not we structure Sukuk for the public to make money? That's the idea. That's where trying to bring wealth and prosperity to the public. That's the initiative, basically. So retail market can be used and traded either in the stock market in the context of Malaysia, Bursa Malaysia, or over the counter via appointed banks, meaning that's similar to the structured products, similar to the stock market. So it goes through brokers to reach the public. And basically, the idea of the Sukuk framework is to basically meet the retail investor demand and to access, again, a wide range of the investment products. And this one to promote, of course, great participations retail of the in the Sukuk market, and also to access retail investors to the Sukuk, because the Sukuk market is dominated by the corporate investor and sophisticated investors and the big guys. So we need the public to be part of the game. Of course, in the context of Malaysia, the retail Sukuk will be issued and traded in the stock exchange Bursa Malaysia or over the counter via appointed bank. And this is to, as I mentioned, to have a broader concept and investor will be educated slowly before basically the trade takes a very sophisticated structure. But they are not traded in the secondary market. So that's one of the restrictions of the retail. Sukuk, they are not traded in the secondary market, not similar to the normal Sukuk that we know. It traded because it has been designed for the retail market. So you have to be careful how to address those basically certificates, because it's a new instrument and you have to go slowly before in the future you may open up the tradability of the retail sukuk in the secondary market. And also public can only sell the retail sukuk to the same place where they have purchased it. Meaning if you purchase from a retail bank, if you want to redeem, you go and redeem from the appointed broker of the bank. Meaning the appointed bank, you buy from him, you sell to him. This is to control the retail market sukuk, because when you do a kind of new initiative, you have to be very conservative, number one. You have to control the portfolio and the box very carefully until it is tested and people are familiar with it, and the demand is growing, and regulations is tied up, and the case has been proven it's successful. Then you start be easy, make things easy to people, and maybe you create a secondary market and it goes like this. But at the beginning, so far, that's the restriction. It is not traded in the secondary market, number one. Number two, if you want to redeem from the point that you have purchased. We have so far 3 countries that have embarked on this exercise, which is Malaysia, Indonesia, and Pakistan. They have embarked on the retail market issuance. And this is basically to create, as keep mentioning, this financial inclusions and Sharia compliance financial product to the public. And it's a part of the agenda of basically prosperity and the redistributions of the wealth and profit sharing. So hopefully more sukuk issuance will come and more countries will embark on this exercise. I think we'll come to the end of the session. I will stop here and maybe open up the sessions for Q&A for the 10 minutes that we have before we take a break. And we spend the last sessions in covering these 5 clusters of topic. Any question?
Dear participants, if you have any question, then you can raise your hands, or you can write in the chat box, or you can ask directly. Thank you.
At the same time, I try to check the chat box. So far, nothing in my chat box, but if you have any, but there are some announcements here that you can read from Alhuda. I mean, any questions either related to yesterday or this morning or to the existing slides? So the session is open. I try to.
Sir, there is a question that
Yeah.
what are the major differences in the bond and the sukuk with respect of capital repayment?
Well, with the capital repayments, basically, again, here you have to distinguish between the, of course, let's start with the conventional, which is very straightforward. The relationship between the issuer and the investors are basically financial obligations. It is a debtor and creditor relationship. So basically, I lend you money with a fixed coupon rate of, let's say, 5%. So I will enjoy the coupon of 5% interest rates on a semi-annually basis within the 10 years. Upon maturity of the 10 years, give me back my money, capital 100%. That's very straightforward combinations and equations for conventional. So all fixed or guarantee. And it is a financial obligations. It is a debt relationship between creditor and a borrower, or a lender and borrower. That's basically the obligations and the contract and the certificate. Now, when it comes to the sukuk, yes, we have issuer, we have what's so called investor. That's number one, same like a bond. Number two, we will receive a semi-annual payment coupon rate similar to the bond. The only thing is that This fix, if it is ijara, which will be very close to the structure of bond because it is fixed and ijara could be fixed. But if it is an equity, it will be not fixed, it will be expected. But still, you will see the 5% similar to the bond. Bond, it is a fixed coupon, 5%. The Sukuk, it is 5%, but not fixed expected rate. Because, as mentioned by the IOFE and the discussions of today, you cannot have a fixed return on the equity. But what you can do, you can put the expected rate of return. But how to meet the expectations of the investor, especially the investor who are coming from a conventional perspective or who don't have a good knowledge about Islamic finance contract. So what you will have, the IOFE allow, there are three mechanisms to manage that expected rate. In other words, you try to make the expected behave like a fix. That's the idea. You try to create a mechanism to make the expected behave in practice like a fix, to meet the expectations of the investor. So what you have to do here, you have three ways. One is has been criticized by IOFE, meaning if there is a shortfall on the account that do the distributions, profit distributions on a semi-annual basis, shareholders issuer will inject Qard Hasan to keep the distributions on. Upon maturity, you recover your qard. That's one has been criticized by IOFE, but some of the Sukuk, they still do it. Option number two, create a reserve to build the reserve to manage that expectation. Number three, to put the profit equalization reserve, which is somehow similar to the reserve to manage again the expected rate of return. So meaning in the form, it looks like conventional bonds, but in substance, it is different. Number one, there is no a commitment to be fixed, but it's expected, but you create a mechanism to make the expected looks in practice like the fixed. That's number one. Now, the other points with regards to the bonds and the Sukuk upon capital payment is that upon maturity, basically, bonds will redeem their capital. But in the case of Sukuk, again, we have to distinguish between a different type of Sukuk. If it is Ijara, you will end up similar to the bond. So meaning that if you put an Ijara structure, you don't see much different between bonds and Sukuk. And the reason being is that, again, I keep praising Ijara because Ijara is a very strong contract. That's number one. Number two, IOFE allowed to redeem using the nominal value, making you exit with the same amount, meaning you resell the asset with the nominal value, then you will get your capital back. And the difference between conventional and Sukuk, conventional is loan, the Ijara is buying and selling, meaning buying the asset and selling the asset. There is no loan that has been created. So if you look at the Ijara structures, with the bonds, you will see similarity in the form, but of course, there are differences in the substance. Now, if you go to the equity, the scenario is a bit different. It's vary from the conventional in a way that upon the maturity and redemption of the Sukuk, it depends on your luck, because IOFE did not allow to redeem with the nominal value to end up with the same scenario of the conventional because it's an equity structure. So you have to redeem with the market value. Now, if the market value is within your capital, so basically you exit similar to the conventional. If it is similar, if it is above your nominal value or capital, so you may take your nominal and you give the balance as incentive if you wish to the issuer, then you will end up with the conventional bond. And if the issue is only in case the market value is below your nominal capital injected. That's basically, practically, you may suffer a shortage in your capital redemption. In summary, conventional, the capital and the coupon is fixed throughout. In Sukuk, coupon payment semi-annual is expected. Redemptions, market value, fair value. How much, you don't know until it's happened. But the issuer, of course, with the all advisors, try to structure a sukuk in such a way to manage those risks and to manage this expectation, like as I mentioned, the PR is smoothing the return. I don't think you may have a problem. I'm talking in overall because this afternoon we have some cases default. I'm thinking in overall. In overall, you don't have problem with the periodical payment throughout the tenure practice, the experience of Sukuk. You don't have a problem with the periodical payments, semi-annual payments throughout the duration. You may have only problems with the redemptions value. Redemption, that's basically the one that make it a bit different because you have a mechanism how to manage smoothing of the return, which is a good as approved by IOF and IFSB. But when it comes to the redemptions of the Sukuk and getting back your capital, that's basically, it's out of your control because it's a market value. It is basically, it depends on the economic conditions. It may go up, it may stay at the same value, it may be below that. So I may say in the context of Sukuk, those are not certain. In the equity structures, I'm selling in the equity structures. In a sales base, I don't think it's an issue. In the Ijara, I don't think an issue because you have a predetermined price. You have to do your math and calculation, your projections within the 10 years maturity, for example. But for the equity, you don't have control on that. So that's basically the answer for that. Yes, there is a request for the presentation to be sent. I think the organizer, Alhuda Center, and Raisa, we will take care of that. Inshallah, we will share with you the presentation, the two presentations of yesterday and today later on, inshallah. Is there any questions? Or otherwise, we just maybe take the second break. This is an issue, actually, the one we just highlighted here. It's an issue in the conventional. But you see, just to share with you before we close, we just have 1 or 2 minutes before I close. You see, even conventional financial institutions are buying Sukuk, which means they know the type of risk that has been highlighted before, and some of the issues that we are going to highlight after the break. They know about those risks, but yet they subscribe to those Sukuk because, of course, of the good rating, because of the being sovereign Sukuk is one, and if it is not, it's a big corporations issuing that, and so and sometimes because of the structures. If it is asset-based, and sometimes if it is maybe ijara, and even if it is a musharaka, the standing of the issuer will be and the third-party guarantor on the credit enhancements. Basically, those mitigations. So they know that conventional interest and capital is fixed and guaranteed because it's a money lending, and they know in Islamic the semi-annual periodical profit distributions and redemptions of the capital is not guaranteed, but yet they purchase the Sukuk and they represent a good bulk of the buyer because the issuer also, they are practical and they are pragmatic. There is a risk, but definitely you have a risk mitigation tool to address those. It doesn't mean, yes, we can expose to risk, let's take the risk, let's take the losses, and we'll be happy to take the losses. No one said that. The Prophet ﷺ said, "Aqilha wa tawakkal," meaning you have to tighten up your camel, then do the tawakkul, meaning you do your risk management, do your best, then do the tawakkul. So it is the same. You have a risk, you have to manage that risk. You have to put the different mechanism and measurements to address those risks to meet the expectation of the investor, because at the end of the day, no one, even a Muslim, no one wants to make losses. Even a Muslim, everyone wants to make profit. So you have to address that concern, which is a legitimate Sharia compliance way without compromise on the Sharia rules and requirements. So the answer, yes, the risk is there. It's not guaranteed, but there are some risk mitigations and mechanism that has been put in place to address the concern of the investor. This is why we have seen a lot of investors from a conventional market buying Sukuk. All right, I think maybe Raisa, with this, maybe we can have the break and come back later on to cover the last session. Yes, Raisa, are you there?
All right, thank you so much, Dr. Easton. Now we have to take a lunch break for 1 hour. Dear all participants, you can now enjoy the lunch break. We will meet again after 1 hour. Thank you.
Thank you.
Dear participants, welcome back from the lunch break. Now we have to start our session that is about 45 minutes. After that, you all have to join the grand closing ceremony that will start after 45 minutes. Those who will not join the closing ceremony, they will not be awarded with the certificates. The Zoom link of closing ceremony will be shared in the chat box. Thank you. Dr. Asen, now you can continue your session.
Okay, thank you very much. Bismillah ar-Rahman ar-Rahim wa salatu wa salam ala Rasulil Kareem. Let's carry on our discussion within this time of 45 minutes. Try to be free, to be a bit focused and quick in a way to cover the materials and join the closing ceremony on time. So let's start with the guarantee, and in the guarantee we have some aspect related to the risk and collateral. I may say in overall we have discussed these points mainly in the risk management when we talk about the area and the risk, and we share the different types of risk as highlighted by the IFSB related to the originator, to the SPV, to the trustee, and to the issuer, and to the servicer, and to the investors or the Sukuk holders. This is another comparison looking at the bond and the Sukuk kind of risk they may share. And we start with the item 1, which is the default of payment. This kind of risk is applicable for both and could be regarded as a credit risk, which I have mentioned it later on, because some of the payments, when it's due, and if there is no payments on time, so you may have a kind of credit risk wise because of the obligation to pay. So it is applicable to bond and sukuk. Also, restructuring of the instruments, both are subject to this restructuring because at the end of the day, sukuk is an instrument, it's a contract, and sometimes the parties may come to relook at the rights and obligations and the responsibility and the liability and try to readjust them, and that one may lead to kind of restructuring or rescheduling of the facility, especially if the financial standing is questionable. Uh, the reserve and the and the profit, maybe I may say it is more unique to sukuk compared to bond. By right, we shouldn't take the bond. And the reason being is that bond is a fixed return, so they don't have this kind of reserve to be built or any kind of mechanism to be in place, because at the end of the day, it is built in the cash flow projections in the portfolio of the account that's basically pay the semi-annual coupon. But the issue of sukuk is that the obligations to pay doesn't come from the shareholder's pocket, but it comes from the joint venture of the sukuk portfolio, especially in the equity structure. This is why it has to be built within the joint venture. So this part is more unique to sukuk and it is not applicable to bond. Bankruptcy of the issuer, it is applicable to bond because at the end of the day, they are business entity, they could collapse. Credit risk, we mention it because sometimes, as has been discussed previously in the trading of the IOFA requirements, it may create a debt portfolio. And if there is a debt portfolio, so we are talking about credit risk. Liquidity risk also is applicable to both because it depends whether the secondary market is active and the liquidity is easy, or it may have some issues. So as you can see, most of the points that have been highlighted when we look at the sukuk and we look at the bonds, they may share most of the issue with some exceptions related to the profit equalization reserve. But because both are financial instruments, both having a rate of return, both basically have a tenure, both they have a kind of cash flow projections and so on and so forth in the form. But when it comes to the substance, of course, bond is a structure based on financial obligation between the lender and the borrower, and the sukuk is based upon a contract relationship between the issuer and the investor that could be in a form of equity base such as musharaka, or lease base such as ijara, or basically sales base such as istisna salam al-murabaha. Now, with some specific risk that is pertaining to the sukuk, which is not applicable to bond, is the Sharia non-compliance risk. It is more relevant to sukuk compared to bond because sukuk is based on Sharia compliance, and having the Sharia non-compliance risk is applicable to sukuk, not bond, because bonds, they are not built upon Sharia requirement. The other one, the transformation risk, which is most related to the sukuk and the Sharia compliance product compared to the bond, because bond from day one until maturity is lender and borrower relationship. It is a loan based on credit, loan based on interest charge. But for the sukuk, it may shift the risk according to the stage and status of the course of the sukuk. You remember in our discussion in the trading, if we are talking about the equity structures, when you raise funds, basically the rules applicable to that one is the sarf, meaning that it is the currency rules which is applicable according to IOF standard number 1. Now, if you move that one into a kind of a productive asset, so the risk will change from a being sarf, liquidity, to be an asset. And it depends on the asset. The asset could be, as I mentioned, tangible, could be services, and could be usufruct. So the risk will transform. In the murabaha, the portfolio of the sukuk will be with the originator upon purchase. Then when you can trade the Sukuk Murabaha, but upon sales of the Sukuk, it's created that portfolio when Murabaha Sukuks cannot be traded. So the risk will be shifted and changed and transformed from one stage to another stage. And this is a very important and very unique risk pertaining to the Sukuk and Islamic finance product compared to the conventional. And basically, uh, the issuer, if we take the example of issuer in our previous discussions, the issuer could be the partner in the musharaka structures, and at the same time, the issuer will be the manager, the appointed manager, and basically it will be in some of the cases the guarantor. So you can see the risk has a different aspects, may change and transform from one stage to one stage. So it is a very unique. The other unique risk is a reputational risk. Of course, the conventionals could have this, but the degree of the impact is lesser compared to the Islamic, because here we are talking about the Islamic features, the Islamicity of the what's so called um, the products. We are talking about the legitimacy of the return. We talk about the permissibility of the wealth accumulated, and so on and so forth. So, in case of any shubha or doubtness that may tarnish the reputations of the risk, it may impact substantially the status of the non-compliance and even the status of the sukuk issuer compared maybe to the conventional bond, where they have maybe a reputation risk, but it is not according or with the same impact of the conventional. Maybe it is very narrow to the corruptions and some other problems and some manipulations of the rate, of course, that could be there. But in Islamic, it be extended to Sharia non-compliance reputational risk because it is an Islamic financial institutions. So it has branding and sukuk basically, and it is a Sharia compliance, which are basically have features of transparency, fairness, honesty, compliance, permissibility of the income, disclosures, and so on and so forth. So if you compromise this, you may expose the business portfolio to what's called reputations of branding. So this is quickly a kind of comparison between the type of risk between sukuk and bonds. The next point is basically talking about some of the IOFI collateral on the equity. I think we have discussed this one. Then it has been recapped again here. And here we are talking about the issue related to the type of sukuk. And as we have mentioned, the type of the underlying Sharia contract will determine the status of the collateral, permissibility or otherwise, and the permissibility of the guarantee or otherwise. Ijara, for example, and sales, they don't have a problem and challenge when it comes to the guarantee, as you mentioned it, because Ijara by default is basically fixed. And sales by default, it is fixed. So you don't have this issue. But the equity cannot be fixed. And as a result of that, anything that lead to fixing the capital or return may trigger the issue of non-compliance. And as a result of that, you have to observe carefully this issue. And this one of the points that has been discussed and highlighted previously in the pronouncement of IOFI 2008 when we highlighted the 6 points, and one of them is basically the issue of the purchase undertaking with the nominal value. So if you design a purchase undertaking by the issuer with the nominal value, you may end up in a structures of guarantee, which put the sukuk under debate and a criticism. This is why the recommendation of IOFI in the practice is that you repurchase by according to the market value or the fair value, but you have to avoid the nominal value. Nominal value could be applicable to Ijara only. This is why, as I mentioned, Ijara in the form is very close to the conventional bond, but it is different in its substance. It is to me, it is similar to say this is halal chicken and non-halal chicken. So both are chicken, but this is halal and this is not halal. Same bonds and Sukuk Ijara. In the form, they are the same, but this is allowed because it is a Ijara contract, and this is not allowed because it is a conventional loan by charging interest. So again, equity is the issue. When we say equity here, we are talking about musharaka, wakala, and mudaraba. Now, as a result, the collateral is allowed in the equity provided it is, as we mentioned it, links to the misconduct, negligence, and the breach of the term and condition. If you put clause under the guarantee in your legal documentation and you link it to this, you don't have problem with the compliance. But if you just put it without qualifications, without any linkage to the negligence or misconduct, you may have a problem in your structuring of sukuk, especially as I mentioned, if it is musharaka wakala or mudaraba. And of course, it is not permissible to provide a fixed return on the equity structures, but it is permissible to have an independent third party to provide a guarantee, as we mentioned in the case of Dana Jami, which is a government-linked agency that provides enhancement for the sukuk. That one is allowed if it is a third party because it is not within the venture, but it is outside of it. And also it is permissible for the issuer to basically to the issuer of the certificate to offer some tangible personal guarantees. This is more related to the say previous point related to the performance, meaning that he didn't compromise on any misconducts or any terms and conditions that has been agreed upon. If he does, it will trigger the guarantee clause. I think this one we have discussed it before in the clause of IOFI and also in the previously in the tradability of the sukuk. Then we have a recap it here as a focus point for discussion. Furthermore, the guarantee in the liquidity facility, as we have mentioned it also in the IOFI pronouncement, because it is related to this, it is not encouraged in the equity structure, mudaraba and musharaka, as we mentioned, meaning in case of deficit of the account that is used to do the periodical payments to the sukuk holder. So the liquidity facility where the managers is leveraging on the shareholders to inject, or the issuer to inject qard to facilitate the payment. This one has been criticized by IOFI. And what has been recommended? According to the IOFI, I think the statement is here. It is not permissible for the manager of the sukuk, regardless of whether the manager act as a mudarib, investment manager, or sharik partners or wakil. So as I mentioned, the problem is wakala, musharaka, and mudaraba. To undertake offer loans to sukuk holders when actual earning fall short of expected earning, but it is permissible to establish reserve account for the purpose of overcoming such shortfall to the extent possible, provided the same as mentioned in the prospect, which means that in the facility, liquidity facility, IOFI doesn't recommend to or doesn't allow to use the qard and loan from the issuer, but it recommends to build a reserve or account or profit equalization reserve to manage the periodical payment to the investor. So that is the first, first and second point related to the some of the comparison between the sukuk versus bond and the IOFI regarding to the equity, which, as I mentioned, it has been discussed before, and we have recapped it here. Now, the following points we would like to discuss is number one, the rights and remedies in the view of the Sharia. Then we talk about the assessed default in sukuk. Now, when it comes to the right and remedies in the view of the Sharia, we have to start from the contract, the permissibility of the contract in the first place. That's number one. Number two, we have to appreciate that the sukuk at the end of the day, they are built upon a contract. Number two. Number three, contract by definitions is basically containing the terms and the conditions, specific rights, responsibility, obligations, liability of the contracting party engaged the contract, being wakala, being a mudaraba, murabaha, and so on and so forth. So this is very important points. And as a result of that, the what's so called Sharia acknowledge the remedies as a result of whatever case and scenario that may happen. And if we look at the rights and the obligations and related possible remedy as a result of any course of actions by any one of the parties, we can see they are divided into three. Number one, Sharia conditions and requirements. This is, we call it in Arabic, الشروط الجالية, meaning that Sharia put the term and condition. This is a Sharia TNC. You can't negotiate. You can't negotiate. It is a Sharia TNC. So you have to comply with. So it is stipulated by Sharia. It is granted by Sharia. Number two, stipulated terms and conditions by the contracting party. This one we call it الشروط الجالية, meaning TNC has been created, has been stipulated by Sharia. By the contracting party. And this is acknowledged by Sharia, meaning Sharia give the right to the contracting party, in other words, give the right to the issuer and to the investor to negotiate additional terms with the objectives to basically secure their interests. I'll just give you an example. Musharaka. Musharaka is a non-binding contract. So the term of Sharia, Musharaka is non-binding contract. But the investor will say, we want to make this contract binding for 5 years or for 15 years according to the tenure of the Sukuk issuance that is allowed. Because terms and conditions are permissible to stipulate, provided they don't make the halal haram and they don't make the haram halal. As long as they honor the prohibitions and the permissibility, you have the right from Sharia standpoint to stipulate and list your needs and requirements and conditions to protect yourself. That's your right. So this is a stipulated term, conditions. The number three, it is market and ORF conditions and requirement. It is known as a commercial, what's so called custom. It is known as best practices. It is known as a template contract and templates, what's so called TNC, where most of the people do it. Most of the people. So sometimes it's related to Sharia. Sharia will dictate. Sometimes it is related to the contracting party. The issuer and the investor will dictate or will stipulate provided they agree. No one has the power to enforce. It is based on mutual consent. We call it in Arabic the element of taradi, the consent. Consent is very crucial. Any stipulated contract should be subject to the consent of the two contracting party. Then the third one, basically it is driven by the market practice, it's the best practices. This is how the drafting of the documentations according to the market practice, according to the law regulations, according to the court precedent cases, according to the experience of the market. This is how the legal firm, the lawyers, the expertise of law used to draft this kind of contract. So you follow the trend. As long there is no violation to Sharia, no issue with that. So at the end of the day, rights and remedy from Sharia standpoint are taken, number one, from the Sharia, number two, from whatever stipulated by the two contracting party and whatever agreed by the practice of the market. If we are taking Sukuk, so we'll take the template of drafting Sukuk as basically a benchmark or a point of reference to draft the documentations, whatever remedies right that has been highlighted. Basically, Sharia has no objections on that, provided basically it doesn't make the halal haram or make the halal haram. So as you can see from the above, we have the rights of the contracting party, we have risk mitigations and interest protections of the contracting party, and you have remedies and compensations that could be basically captured within this legal documentation. So this is with regard to the rights and remedies, and beyond that, the term and conditions and the rights of the contracting party. So the rights and remedies are agreed upon and part of the contract. So if they are agreed upon and they are stipulated, it will be part of the legal documentations of the Sukuk. Now, the second point that we would like to talk about is basically some of the Sukuk cases or Sukuk default cases. Number one, of course, Sukuk is a financial instrument. That's number one. Is a contract. Number two, um, at the end of the day, the parties are not angels. People do mistakes. Contract sometimes is not in your favor. Sometimes your financial standing may change because of the economic assumptions. Like, for example, these days with the coronavirus, the business is slowed down, The many people have impacted financially. Millions of people lost their jobs. Performance of many what so-called companies and firms and financial instruments are not as per the expectation. So many things goes wrong. And as a result of that, the TNC will be impacted. When the TNC is impacted, the default will be triggered. Then the negotiations will start. What to do? It is to reschedule, it is to restructure, or it is to terminate. So that's basically the issue. So sometimes if the conditions are good, so everybody is happy. If the economic conditions and financial conditions are good, so the Sukuk may take a different course and take a bad result. So one of the main issues that trigger the default, and you can see it in the default clause when you go to the legal documentation and look at the default, it is related to the payments. And as you know, because you see two things, two things for the Sukuk. When the Sukuk started, so what you will expect? You will expect a semi-payment coupon, semi-payment a profit or semi-payment rental, whatever, it depends on the structure. Just call it semi-payment or semi-periodical, semi-annual payments. As long as you are getting this, everybody is happy. Why? Because the redemption is after 15 years. Example, if the tenure is 15 years. So meaning that as long as you get your semi-periodical, semi-annual payment, you are happy. Until 15 years, you redeem. Meaning, in other words, the key problem for default is not being paid on time. Because if you are paid, you're happy. This year paid, good. At the end of the day, second payment, good. Next year, good. No problem. When you don't pay on time, that's basically the potential default. Similar, if you have a home financing, because at the end of the day, Sukuk is a financial instrument. Similar, home financing is a product, banking product. Now, if you have a home financing of 20 years, and you have an installments, monthly installment payment, and it is debited from your credit from your account, credited from your account, debited from your account. No, as long as you pay within 20 years, the bank will never call you. And the bank will never bother about you. Within 20 years, if you pay on time, you will not receive one call from the bank. So when the bank will call, and when the potential default trigger, and when the restructurings will come, when the rescheduling may come, if you don't pay once, twice, three, so a status of default, you will start receiving communication, you didn't pay, letter of notice, then it goes to maybe the court, and the default, rescheduling, the problem started. So that's why we put it here, non-payment is the key issue. So as long as the investors receive their payment on time, they will not bother until maturity when they redeem their capital, if there is a capital to redeem. Because some of the structures, there is no capital redemption, but it is amortizations, meaning that it will redeem basically by time. It's amortized through the years. especially related to the manfa. Manfa is that amortization process, is not redemption of capital. So here, failed to pay any amount due from it under any of the transactions documents basically would trigger the problems of default. And always you will see the clause of default, it is related to the failures of payments. It's not related to the redemption of the capital, because the redemption of the capital will come upon maturity, meaning already mature. But here the problem is the payment, similar to home financing. As long as you pay the home financing, the bank will not bother calling you. But if you don't pay once, so the SMS, WhatsApps, the phone calls, emails start to come. And if after 3 days, 3 months, basically, they may start some kind of legal actions, the recovery process. So it's the same for the and also the other thing that may trigger is the breach of the term and the condition, meaning that start to have a negligence, start to have a kind of misconduct, may compromise on the sukuk. That may also trigger what's so called case of default. And of course, we have after that the cross default and winding up of the institutions. I think we are left with 15 minutes. Let me do at least to take one or two cases. So we have here the one of the cases is Dana Jami. Sorry, is Dana Gas. So Dana Gas is one of the issues that are basically defaulted. It is a kind of power, 250 millions. It is Mudaraba structure. Sukuk issued in May 2013 and defaulted in 2017. And it is issued in Mudaraba with 700 million in May 2013 with 3.5 year term. This is a short-term Sukuk, and it has been listed in the stock exchange. Reason for default basically declared that the issue, the Sukuk issue are no longer Sharia compliance. A change in Islamic finance over the year have the Sukuk unlawful in UAE. So, and the Sukuk Sharia compliance here, the purchase price is fixed, the profit payments is guaranteed, and the distribution is based on interest. That's basically the complaint. Why? Because it's Mudaraba, so the purchase price should not be fixed, otherwise you compromise. Profit payment should not be guaranteed because it's Mudaraba. And basically, profit should be based on the performance of the underlying, should not be fixed and cannot be treated. As a result of that, it will be treated at interest, meaning that if the purchase price is fixed and the payments is guaranteed, so basically the treatment of the return is looks like interest. So here, just for the record of the participants, I'm not making judgments on this Sukuk, just to share with you. That's what's happened, and that's what has been presented, and what has been provided. So I'm not with or against the case, because sometimes people may defend their case, they may defend their Sukuk, and so on and so forth. So I'm not saying this is right or wrong. So I'm presenting the case and the reason for default and the reason for debate. And of course, on 13 June 2017, presented to the restructuring, citing the structure was no Sharia compliance. And on 15 June 2018, secured 94% approval of the proposed restructuring on the term of Sukuk. So 2007, the Sukuk issuance in 2013, and it was restructured of 700k million with the Sukuk, meaning that they have fixed, meaning that they have fixed the profit, the purchase price mechanism, and they have fixed the profit payments guarantee elements to make it Sharia compliance. So this is the first case. The second case, the second case is Golden Belt. Try to go quickly on that. The Golden basically belt, again, it is a real estate company with the amount of 650. It is Ijara Structures, and Sukuk issue in 15 May 2007, and it has been defaulted in 2009. The default is a payment rental. As you can see, Ijara, it doesn't have problem with non-Sharia compliance because, as I mentioned and keep mentioning, it is very strong, a resilient structure. So, but the default is from the payment, meaning if you don't pay on time, so we have the right to declare the Sukuk as defaulted. So background, it is a family business owner of Saad Group, Mania الثانية بين one of the basically richer people in the world, and they issue Ijara Sukuk in 2007 with 615 million. So it has a risk there. Keep in mind, when I receive some of the questions I mentioned, how to choose your business based on your expertise. So this family has a estate business. So basically real estate business, meaning they have what's called properties. This is why they choose Ijara. So it is in line with their business portfolio. Of course, defaulted on financing of 15 millions, 15 points, defaulted on the financing, 15.7 billion included Sukuk. In May 2009, Saudi Arabia Monetary arrested, frozen the asset of Saad Group. And in 2009, he defaulted in the rental payment. And of course, in 2010, it was terminated and issue a promissory note of 650 million. So issue in 2007, 650 millions, default in rental payments, Sukuk termination. It has been terminated actually, not restructured, because there is nothing to restructure because the structure is sound. It is just, it has been accelerated and terminated accordingly. And when you do termination, you accelerate the payments and whatever outstanding become due. So what he did, he issued promissory note of 650 million to BNP Paribas to execute the payments and terminate the Sukuk accordingly. So this is one of the cases. I think one of the cases also that you heard about it is Nakhil, which is in Dubai, owned by One World Dubai. And it was actually rescued by Abu Dhabi. And it was a very famous case over there. On restructuring quickly, restructuring is basically same process, meaning that if you have a default case or you have an issue, so what you have to do, either you reschedule if it is related to the payment, or you structure if you have a problem with the validity of the contract, which means that in the case of, if I go back to the cases, if in the case of golden belts, they could do scheduling, rescheduling. They could do rescheduling because it's about payments only. But in the case of Dana Gas, it is restructuring. Why the restructuring? Because sometimes you cannot rectify the Sharia non-compliance, then you have to restructure. So the rescheduling sometimes is related to the payment. Restructuring is related with the redesigning the structure of the contract itself. And for the sake of the time, I'll just jump to the case, which is Garuda Indonesia that has been restructured. Garuda Indonesia is basically the national airlines of Indonesia. Its order book basically is 1.9 billions. By geography, 56% of the deals was, this is the distribution of the Sukuk, was basically deducted to the Middle East, followed by 31% of Asia, remaining 12% to the investor in Europe. You can see European investors took 12% from the issuance of Garuda 2020, and it is a recent issuance. And of course, by investor, banks agency took the bulk of the offering, which is 52%, and private bank, private corporations, fund managers was allocated 29% and 19% respectively. Garuda basically Sukuk offer was done without any government financial institutions guarantee, meaning they didn't take the guarantee. So number one, it removed cost, and number two, because financially they were strong. And making it's the first Asian Pacific national flag carrier to successfully basically issue this of currency of USD, of course 500 million size with a profit rate of 5.9. Currency USD, maturity 29 May, of course country Indonesia, tenures 5 years, and the date of issue 29. This is the arranger, this is the advisor. Now the issuer, the Indonesian Airlines, Garuda Indonesia, was forced to extend the maturity of its 500 million Sukuk. So it is, you may say it is rescheduling, or it could be restructuring by 3 years, meaning that they need an additional 3 years uh, to be able basically to redeem, and the reason to the drop in the airline travel to the COVID-19. I think everyone knows that uh, the, the most impacted sector in the economics is basically tourism, traveling, and basically business airlines. Some of them shut down, and basically it is expected that the Sukuk Airlines issuance will face this problem. So Garuda was issued in 2020, and they request rescheduling to extend another 3 years because of the situations of the COVID-19. The Malaysian Airlines similarly also they requested the extensions of 6 months to pay the 362.5 million sukuk. As you can see, this is very obvious when it comes to the business of airlines because of the situations of the COVID-19. Uh, so we are left with 10 minutes. So let's go to the following sections, which is related to the Sukuk audit. I think Sukuk audit in overall, it is an examination process, on the terms, conditions, agreements, SOPs, end to end. It is a post exercise done by the audit, and the audit is the third line of defense in the governance structure. And this is some of the definition that you may review. Role of the auditor basically is to comply the audit plan, is to review and do the examination, identify and pick up discrepancy in Sharia non-compliance, provide the cause and the root of the problems, engage with the auditee, putting recommendation and communicate with the Sharia board or the Sharia committee or the Sharia advisor to address those issues. This is the exercise. It is from planning, examination, then you put your report. And the objectives with the audit basically is to ensure compliance, and it is post-exercise compared to the Sharia board, which is a pre-exercise. And the objective to ensure that the Sukuk are Sharia compliance and to address the correction measures, because sometimes you may have corrections, like in the case of Dana gas, so it is fixed, we make it not fixed. If it is guaranteed, we make it not guaranteed. That's the correction that you should do. Now, what you should audit, basically, you should audit the PTC, principal term and condition, the structure of the Sukuk, the Sharia pronouncement and approval of the Sharia board, looking at the legal documentation, looking at the executions and the sequence, looking at the profit distribution mechanism, because there is a concern of IOV there when you look at the facility liquidity. Then area of examination according to the contract. If it is Ijara is a Ijara requirement check. If it is Musharaka, is Musharaka requirement check. If it is Mudaraba, it is a Mudaraba requirement check. Then other area as discussed in the legal documentation section, because we have already presented some sections of the legal documentation, those area which are subject to review. Most importantly, you have to check the Sharia requirement because, as I mentioned in the previously, that there are 3 requirements: Sharia requirements, stipulated requirements, and custom requirements. So the concern and the focus will be on the first one. Even regulatory requirements is a concern, but from a Sharia standpoint, it is not a Sharia breach, is a regulatory breach. So there are Sharia requirements, then the regulatory requirements, then the terms and conditions agreed upon by the contracting party, then the custom and the best practices. So the most crucial part is basically the Sharia requirements, because it may lead to restructuring, it may lead to non-compliance, and it may lead to a default. Others, basically, there are also risk, but compared to the first one is less. And when it comes to the applications, basically, of the Sukuk, it has a very vast applications. We are talking about manufacturing sector, we are talking about constructions, investments, liquidity management, infrastructure project, the government budget, project financing, CSR Sukuk issuance. There are some CSR Sukuk issuance, green Sukuk issuance. There are some Sukuk issuance I think we have presented. They have been issued by Indonesia, by Malaysia, by UAE. There are SDG Sukuk issuance, and there are others like exchange Sukuk, like perpetual Sukuk, like what's called retail Sukuk, hybrid Sukuk, exchangeable Sukuk. All these are innovative structures, forwardly Sukuk structures. soft sukuk, structures, hard sukuk, a different type of sukuk which make the market in a way dynamic, flexible, innovative, and basically it doesn't put the issuer under some restrictions, meaning you have a buffet. Where do you want to go? Which kind of contract you choose? What kind of business sector? So it goes back to the choice of the issuer. It's not, no, you have to do it this way or take it or leave it. There is no take it or leave it, but there are many options that could be considered in the Sukuk issuers that make the portfolio very dynamic and very convenient. I think we come to the end of the sessions and we have 3 minutes left. Maybe let's just make a quick, sorry, let's make a quick, um, quick check on the chat box. Yeah, I think we don't have questions so far. I hope the presentation is clear. And sorry for being a little bit fast, just to make sure that we finish on time. And basically, the organizer will share with you, inshallah, the materials. Then you can go through the presentations and pick up notes and benefit from it, inshallah. With that, thank you very much. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
Thank you so much, Dr. Isin, for your enlightening speech. I am very grateful to you that you took the time out from your busy schedule to address our audience. You gave a great presentation. We all are pleased with your topic and the extent your knowledge. Your remarks triggered new ideas that will benefit our audience for years to come. You helped kindle renewed enthusiasm for our profession. Thank you so much. We also want to collaborate with you in the coming future. Thank you. Thank you so much, participants, for your patience and collaborations. Hope this session was fruitful for you all. Now you all have to join the Zoom link for the grand closing ceremony of the Sukuk workshop that is shared in the chat box. The grand ceremony will be started after 10 minutes. Thank you very much.
I lost my connection.